Not hard, you will also kindly, after vacation, you will also kindly make it tomorrow as to be mentioned.
Only to make it better.
Because you will also hard for the 1.5 hour. You also hard the matter 1.5 hour. You will also remember that I've been asked to address on 2 questions of.
Okay, yeah, upgraded.
I've given notice to other side.
Upgraded matter.
Item number 70.
Upgraded matter.
Item number 70.
Okay, it will appear under the heading upgraded matter.
I've given notice. I've talked to Mr. Sobik Nandi. He also.
Okay. Not under the heading to be mentioned. It would be placed fairly at the top corner.
As you deeply.
May I be permitted to mention a matter before your lordship? Although I put the heading as hearing, but I pray before your lordship to make it come under heading for orders, because your lordship, there is extreme urgency in the matter. It relates to unauthorized construction. A stall has been made in front of my factory gate for which raw materials cannot come in and go out. Matter had been heard before Honorable Justice Abhijit Gangobadhyay in 24 January. Affidavit directions were given. Nothing has been done. The respondents are sitting through.
Are you mentioning upon notice?
Lordship, I have given notice. So Lordship kindly makes it for orders. Because hearing will take long length of time, Lordship.
My lord, may I please your lordship?
Upgraded matter উপরের দিকেই দিয়ে দিন আপগ্রেডেড যেটা এটা আর্জেন্ট আছে আপগ্রেডেড ম্যাটারের উপরে আপগ্রেডেড ম্যাটারে দিলে আবার সেই কম্পিউটার করে দেবে সব লিখে দিলে তবে থাকবে
Malad, with notice, Malad, I am mentioning, Malad, this is 2018 matter, Malad. Regarding.
Do it after vacation, only 5 days. Mayor hearing will not.
May I will.
Court is to pass order.
Selection process of 2006. This is the 4th petition. Malad, only Malad, if I will succeed this petition, Malad, only 4 years I will.
Sir, Roma, only 5 days.
Malad,
You forget about the last
4
day,
days.
4 days.
At least, Malad, petition, Malad. Let it be.
Okay, after vacation.
Malad,
After vacation, yes.
Malad, I have 3 matters. Is the hearing. Malad, place it. Malad, it is appearing in the monthly list. I've given notice for upgradation. Let it appear after vacation. The upgradation.
After vacation.
After upgradation.
After vacation, upgraded matter.
Lordship,
After vacation,
this is a matter. On the last day, you suggested me to service the copy for today. I have suggested. It is a matter of senior citizen, pension matter.
pension matter.
Yeah.
You write it, pension matter, right? Pension matter, pension matter.
My lord, having given notice to the other side,
Yes, yeah.
Hearing matter. After vacation.
After vacation, yes, yes.
Another thing is.
my lord, having given notice to the other side,
এটা নিয়ে নিন।
may I have your lordship's
না, না,
leave to mention?
ওটা ঠিক আছে।
একটু বলছি একটা।
Yes, yes, yes.
May I have your lordship's leave to mention,
Yes.
having given notice to the other side, that a matter which was appearing in the list of my lord Mr. Justice Joy Sengupta as for hearing, till the time the determination of his lordship was changed in the last month, my lord, the matter has disappeared since such time. And so, my lord, we have been given to understand that unless it is mentioned again, it is not likely to come up in the list once more. So,
What is the urgency?
my lord, having explained the urgency, the matter was included in the list of my lord Mr. Justice Joy Sengupta as for hearing, as for final disposal. May I tell your lordship in brief the urgency?
Oh. Okay, it will appear after vacation.
Upgradation. After vacation. After vacation.
After vacation.
Pray for my lord's kind leave to mention a matter, my lord, for upgradation, my lord, after vacation, my lord, it's a pension matter. After 10 years.
Pension matter, mention it,
I have
pension matter.
mentioned it, my lord, on the
Okay.
matter.
এই তন্ময় বাবু পেনশন রিটায়ারমেন্ট ম্যাটার গুলো একটা গ্রুপ করে দিয়ে দেবেন তো
Item 48 of the today's list. So let you remember that this matter was MMR matter, Borarai Police Station.
Yes, yes.
Jali Bapia, relating to that the matter will not be entertainable because 2070 education was dismissed. You also pass this order, can you see? At the
Yes, yes, I can recall.
matter, you will also fix as a fixed matter. Item number 48, this item, you know, be taken up before vacation. Since your lordship has heard this matter at 11, but let it be fixed up tomorrow at the court. Since your lordship heard this matter,
Have you given notice to other side?
Mr. Gali is appealing. Today I will give it. Today I will.
Okay, দিন এটা একটু ওপরে দিয়ে দেবেন।
Lordship, may I be permitted to mention a matter without notice, Your Lordship?
Okay.
This is regarding without
notice.
without notice, Your Lordship. There is an
Without notice.
without notice. There is an urgency, Your
You give
Lordship.
notice then.
Lordship, this is
Come tomorrow.
Lordship,
tomorrow published.
the matter is pending for hearing for so many days, like just face the matter after the vacation.
Okay, it will appear in the monthly list of June. Give it.
May I permit?
Monthly list of June.
Already the list of item number 374 of the combined monthly list in the May. So I am praying for upgradation. That urgency is that the petitioner is a oldest person, lordship. She is an 81 years old. Not get any family pension, lordship, till the.
Okay, write pension matter and give it. Pension matter.
My lord, my lord.
Pension matter.
And lordship, upgrade.
Okay, pension matter. Pension matter. Yeah. But before vacation, it would be what are you doing so long?
80
It is a matter of which year?
2022, lordship.
2022. 3 years you are sitting tight over the.
My lord, may I permit
Now, suddenly before the vacation, when there is only 4 days are left, then you are.
My lord, may I permit to mention one matter, my lord? Senior citizen matter, my lord. Both sides are ready, my lord. If your lordship kindly allow to
Before vacation, do it after vacation.
before vacation, my lord. Very short, my
After
lord. Only 5 minutes are required, my lord. Only
You didn't mention earlier. Now only 5 days. Okay, what is nothing? You are taking chance.
already handed over, my lord.
Long back.
No,
long ago.
Just now, my lord. My lord.
Okay. A pension matter. Yes.
Matter is means motion matter of 2021. It is appearing in the monthly combined.
Monthly list of June. Give it monthly list of June.
I am praying for upgradation, man. Kindly fix it.
What is the motion? আচ্ছা motion update করবে ওটা। এটা motion. Motion.
Lordship, with regard
After vacation.
with regard to item number 75 of my lord's list, lordship, the pension matter. My lord, my only prayer is, my lord, if my lord may kindly fix any creditor, that side of it should also.
After vacation.
My lord, kindly.
No, it will let it appear after vacation. Then you will mention upon notice to the then date would be fixed.
May I have your lordship, kindly lordship. Inclusion in the monthly list, lordship, higher scale of pay, Utpalkantikaran, lordship. Upon notice, I am mentioning.
Yeah, ওটা নিয়ে নিতে monthly list of
Monthly
June.
list of June, lordship.
Monthly list of June. Monthly list of June. Okay, now call the list.
Your lordship, may I mention for inclusion,
Monthly list of June. Hearing or motion?
for hearing.
Okay, monthly list.
Grateful, your lordship.
Yes. Call the list.
Oh.
Yes.
This matter, may I take your lordship? What we have done, we have prepared a list of dates. May I give your lordship a brief overview of the matter? Then your lordship may kindly decide how to proceed it right now. The overview of the matter is that there is a SAFTA, that is South Asian Free Trade Agreement, between certain sovereign nations. India and Bangladesh are signatories or parties to the said treaty. Now, this agreement requires or provides for certain exemptions, concessions for promotion of trade and commerce between the signatory nations. Now, my lord, the petitioner, being a manufacturer and importer in India, imported, my lord, refined palm oil from Bangladesh. The law requires, or the agreement requires that, my lord, a certificate of origin has to be issued by Bangladesh authorities. I mean, the the Bangladesh exporter in that sense, as to what is the value addition or the extent of value addition in Bangladesh. Suppose, my lord, the value addition in Bangladesh is less than 30%, then, my lord, the benefit of this, my lord, agreement is not available to the importer in India. So, my lord, what happened, my lord, in this case? Certificate was issued. The respondent authorities pointed out that the certificate is deficient in particulars. In the sense, the extent or the percentage of, my lord, this value addition or non-value addition was not mentioned, though it was specifically mentioned that there had been value addition in Bangladesh. Now, my lord, having regard to that, the Indian authorities, through appropriate channel, approached the Bangladesh authorities, I mean the government authorities. The Bangladesh government authorities, by two writings, replied to the Indian authorities that yes, there had been the requisite value addition. So this export from Bangladesh and import into India is covered by SAFTA and they are entitled to the necessary concession or exemption. My lord, the Indian authorities did not believe the contents of the said Bangladesh authorities or the writings of the said Bangladesh authorities and issued a show cause notice. This show cause notice is the subject matter of challenge in the present writ petition. Pleadings have been exchanged by all the parties. My lord, I think Mr. Dey appears for the Directorate of Revenue Intelligence and Mr. Banerjee.
I'm reading for customs, my lord, led by
Customs.
Mr. Bennett.
Mr. Banerjee. So, my lord, this will take some time. So, my lord, I leave it to your lordship. If your lordship continues, I am ready, or otherwise your lordship posts a day immediately on reopening, subject to the convenience of Mr. Dey. My lord, can do the matter straight away.
As your lordship will fix, my lord.
Huh?
As your lordship will fix.
And may I just indicate to your lordship, my lord, this will not, though it may appear to be a heavy matter, it is not so. I will not take more than 40 minutes of your lordship's precious time. And I assure your lordship, I will stick to that timeline. But I leave it to your lordship, whenever your lordship wants to take up, since the matter is appearing as to be mentioned, my lord, kindly fix a date and we will do the matter.
All are same matter, similar.
Same. Well, one matter will decide everything.
After reopening, I have a circuit bench.
When your lordship is coming back, well, I'm subject to lordship.
Coming back, I shall start here from 3rd June.
24th, my lord. Subject to my lord.
দেখুন তো 24th ওই জায়গাগুলো কি আছে একটা দুটোর পর কোনটা ফাঁকা
That's a Tuesday, my lord.
হ্যাঁ
24, 25, my lord, I think Mr. Dey and I would be ad idem that it will not take much long. Whichever way it goes, it will not.
একটা
And my lord, it's a
one আর ফাঁকা আর সব 26 সব ভর্তি
Item number 10.
Look, this
I
is,
on behalf of the respondent.
that we tried to move it, Pilot, on Friday. There's peculiar
Mr. Ray is online, my lord. I'm led by Mr. Ray, he's online.
এই
I've got two very
Oh.
short points.
Oh, that matter, yes.
First point, my lord, is that NPA declaration is wrong because they have placed reliance on the wrong circular. My lord, RBI, my lord, issued two circulars, both dated 1st of July 2015.
My lord,
One,
my lord, before my learned friend, senior friend begins, my lord, Mr. Reyes wishes to do the matter before your lordship. My lord, if a short passover can be given for 10 minutes, my lord, he'll be on his way.
I never object, my lord, to any
Okay, pass over.
accommodation.
Oh, my lord, I think Mr. Rey has joined.
My lord, if we are not here, kindly permit us to come back. Maybe at 2 o'clock, my lord, if we can come back.
2 o'clock is a matter. So come tomorrow. That would be better. Come tomorrow. Hmm? Tomorrow is also
The banerjee will,
difficulty.
my lord, decide.
I am appearing in this matter, my lord. I am opposing.
Okay, but they are ready to move this matter today.
My lord, may I
But
just
your
have 10
junior is
minutes?
not.
My lord, just gives it 10 minutes passover, my lord. I'm just on my way, my lord. I'm rushing, my lord. I wouldn't like to do this on the net, my lord. Let Mr. Chaudhary start, my lord. I'm reaching.
Very well.
Let him start. I'm reaching, my lord.
Very well.
But I'm just on my way. I'm walking down, my lord. It's just that. That is why, my lord.
Very
I'm
well.
just on my way, my lord.
Okay.
So, my lord, 1st July 2015, two circulars. Your lordship will, my lord, find these circulars annexed, my lord, to the affidavit of the bank. Now, the first circular relates to, my lord, export packing credit advances, which is, my lord, my business. The other circular, my lord, does not. It relates to everything else. However, for the purpose of declaring my account as an NPA, they have placed reliance on the wrong circular. That's, my lord, my first point. My second point is, today, my lord, there is an MSME circular which requires also of the Reserve Bank. My lord, kindly have a look at that circular at page, my lord, 8 of the supplementary affidavit. I'm sorry, the registration is at page 10 of the supplementary affidavit.
Supplementary affidavit. One amendment application is there. No supplementary affidavit. Oh. Okay. Hey, Tanmay babu. Have you got the copy?
Yes, yes,
Been, sir.
long time back.
Okay.
My lord, please, my lord, look at page 10 of the supplementary affidavit.
Yes.
There's a circular, my lord, dated 29th May 2015.
Yes.
Clause 1, my lord,
Hmm.
is identification of incipient stress.
Hmm.
My lord, identification by banks or creditors before a loan account of a micro, small and medium enterprise turns into a non-performing asset, banks or creditors are required to identify incipient stress in the account by creating three subcategories. So, my lord, they have to identify stress in an account. It's a mandatory obligation. Then, my lord, please come to page 11, clause 2. Committee for Stressed Micro, Small and Medium Enterprises.
Hmm.
Subject to regulations prescribed by RBI, all banks shall constitute one or more committee at such locations as may be considered necessary by the board of directors of such bank to provide reasonable access to all eligible micro, small and medium enterprises which have availed of credit facilities from such banks. So, my lord, this committee will be set up. Clause 3, my lord, is the composition of the committee. Now, my lord, please come to page 14 of the supplementary affidavit.
Yes.
5. Corrective action planned by the committee towards the end of the page. The committee may explore various options to resolve the stress in the account. The committee shall not endeavor to encourage a particular resolution option for restructuring or recovery of the enterprise, but shall endeavor to arrive at an early and feasible solution to preserve the economic value of the underlying assets as well as the lender's loans, and also to allow the enterprise to continue with its business. During the period of operation of corrective action plan, enterprise shall be allowed to avail both secured and unsecured credit for its business operations. The options under corrective action plan by the committee may include: number one, rectification, obtaining a specific commitment from the borrower to regularize the account so that the account comes out of special mention account statute or does not slip into NPA category. Then, my lord, two is restructuring. And three is recovery. But, my lord, please see the first sentence. Once the first two options at A and B are seen as not feasible, due recovery process may be resorted to. So, my lord, only if rectification and restructuring fail before the committee can recovery be resorted to. My lord, please see clause 9 now at page 16 towards the bottom. If the committee decides on option 4I or II, but the account fails to perform as per the agreed terms under 4I or II, committee shall initiate recovery action under 4.3. Now, my lord, it is for the bank to come and show your lordship that they have, number one, assessed, my lord, or taken steps to assess incipient stress in my account. Number two is they have referred me to this committee to be decided by, my lord, the RBI directors, and necessary steps for, my lord, restructuring, and for, my lord, the first step is, my lord, rectification. Rectification and restructuring has been, my lord, resorted to. And as my learned friend Mr. Banerjee rightly points out, page 10, all this is before declaration as NPA. The circular is dated 2015. Now, my lord, see the other circular, which is at page, it starts, my lord, at page 23.
Yes.
My lord, please now come to page 31. My lord, I am being brief. My lord, I am not reading the whole circular. Page 31, my lord. Salient features of the framework are as under. So this is the framework which is to be done before the committee. Then 4.9, structured mechanism for monitoring the credit growth to the MSME sector. My lord, what has to be done? And then, my lord, at page 31, my lord, salient features I. My lord, please see I once. I skipped over this. Before a loan account of an MSME turns into a non-performing asset, banks or creditors should identify incipient stress in the account by creating three subcategories under the special mention account category as given in the framework. So, my lord, this whole process of identification, correction, restructuring has to be resorted to. It's mandatory. If not done, then you can declare, I mean, if I fail, then you can declare me as an NPA. Now, my lord, the short point, my lord, is the Supreme Court today in 2024, my lord, delivered a judgment. My lord, please see, my lord, 2024 10 SCC 292, paragraph 9 at page 297. Thus section 21 read with section 35A makes it clear that the directions issued by the Reserve Bank of India to the banking companies are binding on them and they are bound to comply with such directions. So it's mandatory, binding on the banks. Then below, this notification which I placed is set out at paragraph 10. Now paragraph 11. RBI, in order to make the framework contained in notification such and such, has made changes. Then paragraph 12. This is important. It is pertinent to note that in exercise of powers conferred by section 21 and 35A of the Banking Regulation Act 1949, the Reserve Bank of India, after having been satisfied that it was necessary and expedient in public interest to do so, had issued the master direction called the Reserve Bank of India such and such, vide notification of 2016. Said directions have been made applicable to every scheduled commercial bank, excluding regional rural banks, licensed to operate in India by the Reserve Bank. Amongst the other directions, Direction 4 contained in Chapter 4 thereof pertain to the common guidelines instructions for leading to MSME sector. Paragraph 13. While advising all the scheduled commercial banks to follow guidelines instructions pertaining to MSME, it was directed in Direction 4.8 as under. Then, Lord, this is set out. Now, Lord, please come to paragraph 17.
Yes.
What is contemplated in the framework for revival and rehabilitation of MSME contained in the instructions directions stated here and above is required to be followed prior to the classification of the borrower's account. Milord, please note this, Milord, prior to classification. And it is mandatory, required to be followed prior to classification of NPA. The said instructions contained in the notification are part of measures taken for facilitating promotion and development of MSMEs issued by the central government in exercise of powers conferred under Section 9 of the Act, followed by the directions issued by RBI in exercise of powers conferred under 21 and 35A of the Banking Regulation Act. The banking companies, Milord, please mark this. The banking companies, though may be secured creditor as per definition contained in Section 2ZD of the SARFAESI Act, are bound to follow the same before classifying the loan account of MSME as NPA. We may hasten to add that under such and such, the banks or creditors are required to identify the incipient stress in the account of the MSME before their accounts turn into NPA by creating subcategories under special mention account category. However, while creating such subcategories, the banks must have authenticated and verifiable material with them as produced by MSME concerned to show that the loan account is of an MSME classified and registered as such under the MSME Act. Said frameworks enable the MSME to voluntarily initiate proceedings, so which is what I'm doing now. Therefore, the stage of identification of incipient stress in the loan account of MSMEs and categorization under the special mention account category before the loan account of MSME turns into NPA. Important, before the loan account of MSME turns into NPA is a very crucial stage, and therefore it would be incumbent on the part of the MSME concerned to produce authenticated and verifiable documents, material for substantiating its claim before its account is classified as NPA. Yes, and I am an MSME, registration on record, bank is aware, Milord, it doesn't do anything. Now, Milord, see paragraph 22. In that view of the matter, we are of the opinion that the findings recorded by the High Court in the impugned order that the banks are not obliged to adopt the restructuring process on its own, or that the framework contained in the notification dated 29th May 2015 as revised from time to time cannot be said to be mandatory in nature, are highly erroneous and cannot be countenanced.
22 বলেছিস তো?
So, we'll have the same stand of the bank has been, my lord, accepted by High Court and set aside by Supreme Court.
আমাকে দাম দিলি তুই। এই মাত্র।
Now, my lord, see paragraph 23. Impugned order is set aside since it has been submitted by counsel for the banks and all cases proceedings under SARFAESI have been concluded. Mine is not yet concluded. And the possession of the respective premises has been taken. We do not propose to remand the matter to High Court. However, since High Court has not dealt with others factual, as we clarify, open for the appellants to take recourse to any remedy as may be available for agitating the issues not decided by High Court. So, but in our case, it's not concluded. I have come in time. So, this is, my lord, my first point, that while, my lord, taking steps to declare me as an NPA, it was obligatory of the part of the banks to refer me to, my lord, the committee under the MSME circular set up by RBI, mandatorily required to send me, try, my lord, rectification, try restructuring, and after all of this fails, only then to declare me as an NPA and proceed for recovery. The circular is mandatory, as the Supreme Court says. I am in time. My SARFAESI proceedings are not over. My challenge is alive. So, my lord, at this stage, I am coming and saying that I first have to have this benefit given to MSMEs under this circular, which is said to be, under these two circulars, said to be mandatory by the Supreme Court. This is my first point. Also, my lord, division bench of this honorable court, taking note of this circular, now, my lord, whenever this is done, banks, my lord, have this habit of coming and saying that I am proceeding under SARFAESI Act. You can't touch me. High Court has no power. High Court has no jurisdiction. You go before DRT. Same arguments are always made. That's their, my lord, umbrella. Because if you cross the umbrella, there is gross breach on their part. Now, this umbrella has been, my lord, shattered by the division bench of our court. My lord, please see, my lord, 2014 SCC Online Calcutta 20626. Heard learned counsel for the appellant bank, the entire dispute is with right to declaration of the respondent unit as unviable by the appellant bank. It is not in dispute credit facility was extended to the respondent by the appellant in terms of scheme meant for MSME. Certain guidelines for rehabilitation of these units were also issued in order to promote the MSME units. When an account becomes NPA, irrespective of whether it is a loan facility or credit facility given either under the scheme meant for micro and small entrepreneur unit scheme or otherwise, the loan has to be recovered by the creditor banks. In order to promote micro and small entrepreneurs, certain guidelines are made in order to see that if such entrepreneur has some financial difficulties, a procedure has to be followed which guarantees rehabilitation of sick entrepreneur. Therefore, unless the borrower who borrows is declared as unviable, bank will not be able to proceed further. So this is important. Now, in other words, before proceeding with recovery of amount,
taking recourse to SARFAESI Act, the guidelines meant for rehabilitation of sick MSMEs is required to be followed by the creditor bank. The question is, when SARFAESI proceedings under section 13(2) was initiated, whether the guidelines for rehabilitation of sick MSMEs was complied with by the creditor bank or not. Complaining non-compliance of guidelines is not under clause 7p. This is the earlier circular. My lord, suit was filed for a declaration. The learned judge, after next paragraph, learned judge, after referring to the provisions of the scheme, was of the opinion further opportunity must be given by the debtor plaintiff, providing right of appeal before all other opportunities for rehabilitation are closed. Therefore, learned judge directed plaintiff to file an appeal, etc., etc. Further directed the bank to dispose of the same. Aggrieved by this, my lord, appeal file. Now, my lord, please turn over to the next page. First paragraph, SARFAESI Act is referred to. Then, my lord, please see this. Whether the declaration sought in the unit would be part of SARFAESI proceedings is to be looked into. Reading section 34 and the complaint made in the plaint, that is non-compliance of guidelines for rehabilitation of sick MSMEs, we are of the opinion that the appellant bank could not have proceeded with the matter either under SARFAESI proceedings or under any other mode of recovery in accordance with the procedure contemplated without adhering to the guidelines of rehabilitation formulated by the Reserve Bank of India in order to declare a unit as unviable, and then, my lord, that procedure. And the argument that in a suit no such order can be given because matter should go to DRT was rejected. I am in a better position here because this is a writ petition. And under the SARFAESI Act, there is a provision which bars, my lord, filing of suits. But, my lord, the court, my lord, ignored it, did not follow it. The reason is this, my lord, that when, my lord, any step is taken validly under the SARFAESI Act, it is only then that the exclusion of jurisdiction clause, my lord, starts becoming operational. If there is no valid declaration as NPA, then nothing can be done under SARFAESI Act, and the bar of jurisdiction of civil court or, my lord, the obligation to go to, my lord, DRT because of alternative remedy, that will only arise if a step is taken validly under, my lord, section 13(2) and 13(4). To take a step under 13(2), under the SARFAESI Act, it is necessary that an account has to become an NPA. Here, my lord, I am striking at the root of the matter. My lord, here RBI says you have to do X, Y, Z, give me a chance before you do NPA. You have not done that. So your declaration as NPA is palpably wrong. And I have come for, my lord, setting aside of the declaration as NPA. So therefore, all further steps, my lord, are based on nothing, and, my lord, they fall. So this is, my lord, one part of it. Yes. Now, my lord, my second argument. My lord, please see the affidavit which has been filed by the bank. Page 12 of that affidavit.
Oh,
hand over. And there's no reply to this one.
It supports me, my lord.
Maybe. Malad, may I just point out two things before he starts up, Malad? Just a minute. I'll be taking two maintainability points, Malad. One is, Malad, your lordship cannot look into the supplementary affidavit, which my learned friend has filed, because, Malad, it is absolutely dehouse the pleadings in the main writ petition. You cannot make out a new case.
Let me not finish, then
Malad, that is one
say.
point. No, so that he can also argue on that, because I'll be taking that point. And the next point is, Malad, I have instructions to submit, Malad. The writ petition has become infructuous. Because, Malad, though he says very well, may I just point this out? That is why your lordship should not hear him, because he has completely suppressed all these things. Because the writ petition challenges a 13-2 notice,
Unless
which
I
is
finish, how
no
does
more
he know
there.
what I'm saying?
Which is no more there. So it's beyond the scope of the writ petition. Your lordship can dismiss the writ petition because it's beyond the scope. That section 13-2 notice is no more there. Let him answer to that first.
Milord, please see, Milord, his affidavit, page 12.
What is the
understand his
13-2 notice?
I can
All
understand.
of them are 13-2 notices.
Yes, challenge letter.
But that is a 13-2 notice. 13-2. And the advertisement is of the 13-2. This 13-2 was withdrawn and then 2023 another 13-2 given. Now, my lord,
13-2 withdrawn and
again a new 13-2 notice given in 2023, which has been challenged before the DRT. And my lord, there are applications made by my learned friend's client challenging 13-4 actions under that surfacey notice, which has completely been suppressed by your lordship, and now he's making submissions on MSME.
Very well. Now, Milord, I'll answer the point. Milord, please, Milord, have a look at my amendment application which has been filed. Perhaps my learned friend is not aware. Milord, please see the amendment application. Affirmed in January 2021.
Amendment?
না না ওরা ওরকম করে না তোমার মতো করে না
Amendment হয়েছে?
Yes.
Milord, please see.
My lord, I hope, my lord, the amendment has been carried out. I have not received any amended writ petition. In the manner as we postulate under the rules of this court, my lord. My lord, we have looked up, my lord, I did not find any order amendment. I will stand corrected once he shows that. My lord.
Oh,
Please have a look at.
so let the application be heard first as to whether it should be amended.
Yes,
Your prayer for amendment should be accepted or not.
yes, Milord, please see, Milord. The prayer is for a declaration that of the petitioner's account as NPA is bad.
My lord, when have they moved it? There must be some record. I will stand corrected, obviously.
Lordship has seen the prayer, Milord. I, Milord, have never disturbed.
Amendment application page 7.
Yes, Milord. Please see the prayer which is made, Milord. B at page 18 between prayers C and D, the following prayers may be incorporated. It in the nature of mandamus to issue commanding the respondent to show cause by decision taken by respondent bank in declaring petitioner's loan account NPA and all actions that shall not be set aside quashed, and in the event no sufficient cause or sufficient cause shown, set aside quash the same. Interim order restraining the bank from taking other further steps. So, my lord, my original
This application was served. You have
yes,
to
yes.
But my lord, I never moved.
So I'm moving now.
I'm opposing. Let me file an affidavit.
In the meantime, you'll sell everything and go away.
My lord, what? That is not the problem, my lord, here.
No, of course it is.
No, just a second.
No, let me finish.
Mr. Chaudhary, no. You're moving an application. Why I should
Finish.
not
I
file
haven't
my
finished.
opposition? This is with regard to opposition. Unless
Very well, you file affidavit, but don't take further steps.
that
shown
prayer is
Supreme
not
Court-
that prayer is not there, my lord.
Shown your lordship. Supreme
That
Court
prayer is not
direction.
there. That prayer is not there in the main writ petition. He cannot control the court and say, yes, the amendment application is filed. No, I'm talking about his.
No,
client, not him.
actually, if those letters you have not specified what the letter.
My lord, I'll show you the letters. my lord. They
they
are all 32
in
notices.
the main writ petition.
Yes,
You have
32 notices.
You have asked the court to set aside certain letter three.
Yes.
One advertisement and 3 letters.
Yes.
Pair P.
Yes.
But you have not specified that what is this letter.
My lord, I'll show it for
Okay.
the 32 notices.
I will come
Okay,
there.
now if it is letters or notice in form of a notice under 13(2) of SARFAESI Act,
Yes.
and it was subsequently withdrawn and fresh notice was issued. It was with
Let my learned friend say that all these 13(2) notices.
no, all why are you?
That's what his prayer is.
He's saying that subsequently a fresh 13(2) notice was
Let him
issued.
say very well. Let him say that all these 13(2) notices are withdrawn. Let him say, I have no problem.
My lord,
Not all.
my lord, may I say this?
The
Mr.
note
Chaudhary has-
the
not being
earlier
instructed properly.
13 to notice, that means the notice,
those are not there.
such and
Those
such
are not
letter
there.
are withdrawn.
Let him please record that or withdrawn. So all consequential steps are also withdrawn.
Why? There is a separate. Mr.
Subsequently-
Chaudhary is not aware, my lord.
No,
His
no,
mind has completely
Subsequent-
suppressed from him
no,
that the
no.
13-2 notice, which
You
has
have
been
to-
subsequently issued, that has been challenged by his client.
Maybe,
before
but
the
you have
DRT.
to
Don't say
appreciate.
maybe. Please don't
You
say
have
maybe.
to
You
appreciate.
have not, you have suppressed it from
No, no,
me.
I have not suppressed. I have
now
not
saying it.
finished.
I'm saying this. You have suppressed it. You have brought in a supplementary.
So unless I
doesn't
finish,
show it.
what is going on?
You can, Mr. Chaudhary, you
Wait,
cannot.
let him finish, then I'll argue.
Let me finish first.
What is
My
this?
lord, two things. Can Mr.
Petitioner
Chaudhary
arguing, he'll stand up and he'll argue.
I'm saying you, the facts are.
If he raised the maintainability point, then
And yes, I have to argue.
What is the maintainability point?
Pointing it out, my lord. First of all, supplementary affidavit cannot be brought on record, my lord, where he's making out a completely new case. You have to amend. Amendment. He has not amended the writ petition. Today, my lord, I am saying, my lord, he is making his first case on the supplementary affidavit, which I am opposing. My lord, there are judgments of this honorable court division bench saying that you cannot make out a new case by way of a supplementary affidavit. One you can amend, but that's a different thing altogether. Now, my lord, my learned friend, when he hears that, he says, no, we have filed an amendment application. My lord, he has to show that the amendment has been allowed. If it's not allowed, we fall back on the original writ petition. If it's the original writ petition, my lord, it's a challenge under 13.2 notice. Second, the point which I'm taking, my lord, is that he was aware that this 13.2 notice has been withdrawn, one. Second, he's aware that there's another 13.2 notice of the year 2023. And he's also aware, or rather, I shouldn't say Mr. Chaudhary, I retract. His client is well aware that they have challenged 2 auctions already before the DRT. My lord, if your lordship kindly allows me to place the DRT cause list, from there it also appears there. DRT cause list, it also shows that they have filed before the DRT. Let them say, why did they not mention before your lordship that there is a proceeding before the DRT? That is complete suppression. Now, my lord, what has happened? 2021 writ petition, 2020 writ petition, my lord. Water has flown. Now he filed the supplementary affidavit. That's of 2 days back or 3 days back. Does he mention all these things? What is required to be mentioned, he doesn't mention. And now he makes out a new case. Your lordship will find in the main writ petition, there is no case made out about MSME. Not a single case has been made out. So my first point of maintainability is with regard to the supplementary affidavit not being taken on record. One. Second, my lord, my point of maintainability, that my lord, it's not a pure question of maintainability, but it's an alternative remedy. Your lordships have clearly held, following Shottapati Tandon and all judgments, that securitization matters should not be in any way, my lord, obstructed or my lord, challenged before a high court, because there is a proper alternative forum. So therefore, your lordship will first consider whether your lordship will pass any orders vis-a-vis a challenge to a SARFAESI notice. Where, my lord, now it has become evident, and rather it is on record now, that 13.4 has already been initiated. If your lordship wants, kindly keeps it tomorrow, I'll get all the documents before your lordship. I'll get all the documents. I'll get their application. And, my lord, what Mr. Chaudhary was showing, my lord, that I will come to later, my lord, the judgment itself clarifies where your lordship will look into the MSME thing and where your lordship will not look into the MSME thing. That is not a point of maintainability, so I'll not say that right at this moment. But, my lord, that also clarifies. So, my lord, I'm only saying, my lord, kindly do not take the supplementary affidavit on record. And I'm saying, with instructions, if your lordship wants, I can put in an affidavit that this, my lord, 13.2 notice has been withdrawn. But I can show the document if your lordship wants. I have it. Yes.
Same matter.
My lord, this is of 17th November 2023.
Supplementary 6th May 2025.
Oh, he has it. Oh, he has it. But this has not been mentioned anywhere. Mr. Chaudhary has been
The
supplied.
subsequent 13-2 notice.
Yes, earlier has been withdrawn. Kindly see the last sentence of that page, folks. Last sentence, your lordship will see. So where is this challenge to that? And he has challenged it before the DRT.
Pending.
And when it's showing it's pending, let them say what is SS 790 of 2024. It is their application. It's a essay, it's a surfacing action. Have they said this? Well, that is why I said, would your lordship even open the doors of equity in Article 226 when this person has come before your lordship, suppressing all these things? Before I came before your lordship, did he say that well, his client has instructed that that has been withdrawn? Has he said that? No. Rather, he has started to make out a case of MSME. Then Mr. Chaudhary has been made to say that the amendment has been allowed. Let him show the amendment has been allowed. I'm sorry, Malad, it's very sad.
That amendment has been allowed.
Malad, he just read the amendment phrase.
Okay.
So if the amendment is
So,
not,
Mr. Chaudhary, what you will do?
Now, if he's finished, may I?
Withdraw, you file a
No. Milord, I'll tell your lordship very
You
simply.
file a press challenging that the
No.
benefit or
Tell
the formalities before declaring your account as NPA under the 2015 circular and as per the guidelines of the RBI has not been followed, which is mandatory, which was required to be
Correct.
followed mandatorily.
No, Milord, I have to do it here. I have to do it here, and I'll tell your lordship why.
I am giving you liberty. You file a press.
I would have, but Milord, please see the order on the screen. But my learned friend,
Repetition, but I earlier bench.
this one, Milord.
This one, yes, but this fact was not brought to the notice of the learned coordinate bench when the order was passed.
Which Milord? No,
That
no, Milord, now please hear me for 2 minutes. Kindly take the 10th February 2021 order.
Yes. Yes.
Milord, petitioner's challenge classification of the account as NPA. The first sentence itself, learned counsel places reliance on these clauses. Milord, I'm sorry.
Malad, it's there, abide by the result of the writ petition. That is the order. Malad, I have already withdrawn that notice. Come on, what is there left?
I'm sorry, Milord, not the first one. Milord, please take 19th of February 2021. 19th February 2021.
Order.
Yes.
Yes.
Any step taken in the meantime pursuant to or on the basis of the impugned classification of the account of the petitioner as NPA shall abide by the results of the writ petition. So the court is alive to the fact that further steps have been taken. Today, my lord, if I withdraw the writ petition, all that has happened during its pendency, I will no longer be able to challenge again. But if I succeed in this writ petition after amending the same, everything that has happened in the meantime will go. Now, for restructuring and revival, it is imperative, my lord, that the steps which have happened in the meantime also go.
Mr. Roy, the court took notice of this challenge, although not on record, and on that date you appeared, 19th February.
Malad, may I say this?
Thereafter,
No, don't say anything more.
Won't allow me to
Okay.
Now I'll say.
Okay. Let the court.
Malad,
You
I
all
thought I
know
am
the
Mr.
matter. Know the matter.
But I am Mr. Guy, your lordship called upon me.
He's in.
Court rather does not know. First time he's taking up for hearing. You know, you are appearing.
That's why I got up, Malad. Now, Mr.
Appearing since 2021. Let the court understand. Mr. Rai, on 10th February 2001, the court recorded, a coordinate bench recorded, petitioner has challenged the classification of the account of the petitioner as NPA.
Yes, my lord.
That
Notice
means the court recorded it.
The notice.
Court took notice, judicial
Absolutely, my lord.
notice
My lord, may I say
that
this?
they are trying to throw this challenge.
Yes, my lord, there is no dispute about that.
I'll tell you,
Did I
Lordship, why.
say, my lord, the
You know, just
dispute
take
is
the
not that.
Surface Act once.
My lord, that was vis-a-vis what? What was the player shot for? That is what I'm on.
Lord, may I explain?
Today, your lordship, my lord, if that notice is not there, let us say your lordship is minded to allow the writ petition. My lord, what would happen? The notice will have to go. That the notice is not there, it's already taken. In fact. That is what I'm on.
Lord, may I just
And now, my
conclude?
lord, kindly
He's not
also-
letting me argue. May I just explain?
My
You're
lord,
not. You're
another-
repeatedly
I-
disturbing
my lord,
me
I-
and trying to throw
I'm
me off
sorry,
track.
I tender my apology. Now, my lord, after that, may I say this, my lord? Today, suddenly, it has dawned on him that he has to take this point, that this court is alive to this jurisdiction. in
With
spite
this
of-
issue.
With this
With this
issue.
issue. It
But
is not
he has
new.
not come before your lordship.
And he has not taken you by surprise.
By
Yes.
surprise, because my lord, he has taken the court by surprise.
Don't be so sad.
He has come before your lordship. Has he said before your lordship that it has been withdrawn?
Let-
Today suddenly he comes up, he has it with him. So, my lord, an applicant who suppresses facts
Yes.
from your lordship's
He's
court,
gone back.
including, my lord, the DRT appeals, my lord. My lord, in spite of whatever wrong I do, he is not entitled to any equity. The Supreme Court has been very clear on this. If you leave out any facts which are material, you are not entitled to equity. Has he said it before your lordship that this has been withdrawn? There is a new notice. Has he ever said all these things? I've challenged before the DRT. And he shows an order which is only limited to the players, obviously.
Okay, Mr. Raj,
Well,
since
let
a
him-
coordinate bench has taken judicial notice of their challenge,
Yes, my lord.
now it would not be proper to throw the writ petition from this stage.
My lord,
Rather let the supplementary affidavit be taken on record
no, my lord, I'm
and-
opposing.
and let.
I'm opposing.
Kindly allow my amendment.
Okay. And
An amendment allowed.
allow the court, Mr. Rai, to complete.
Sorry. Yes.
Let the amendment be allowed. Liberty is given to you to file a supplementary affidavit in
My lord,
opposition.
may I say this now?
Supplementary affidavit to your affidavit
Now, my lord,
opposition.
may I say this?
You deal with all these points.
Now, may I say
But since in your presence, the court took notice of this challenge,
My lord,
that they have challenged the declaration of their account as NPA,
my lord,
and,
first-
court proceeded accordingly.
my lord, on the basis of what?
I don't know. It is this
My lord,
challenge,
My lord, a challenge.
Mr. Roy. This challenge has no basis on the pleadings in the writ petition.
That is why
They are going beyond their pleading. But now subsequently they have filed a supplementary.
My lord, kindly grants me liberty
Uh.
to file opposition to the amendment application. I will not, my lord, I am not conceding to the amendment. I'm to oppose the amendment application. So your lordship will kindly grant me liberty to file.
Mr. Roy,
My lord.
my perception, maybe I am wrong. The amendment has already been effected as and when court has taken judicial notice of what is the declaration of a NPA.
My lord, may I just say this, my lord? My lord, may I-
Amendment actually
That is implicit
effected.
in Surface
My lord,
Act because 13.2 is after NPA.
Rather, it would be better to create all the avoid all the complicity and such
my
and
lord,
such.
what
You
I-
file supplementary.
No, my lord. No,
Yeah.
because, my lord, I'll point out two things. Your lordship is throwing out the points of maintainability which I'm raising. Without, my lord.
Let keep
an
it
opposition.
open. Keep those points open. What is
I
the
am
problem?
saying, my lord, first of all, my lord,
Let keeping all points open, Lordship will allow amendment.
amendment cannot be allowed at this stage, my lord, without, my lord, my learned friend having taken steps in moving it and getting it allowed. One. My lord, 2021, an amendment application is made, and your lordship is now being told that yes, kindly allow the amendment. My lord, no, that cannot be done because I have a right to oppose an amendment.
Why didn't you file it?
Yes,
There was no direction.
Yes.
They have not properly.
What
moved it.
direction like?
They have not moved it.
But question is that I have got your point. Question is that you have not challenged these two orders.
I don't need to.
Yes.
I don't need.
10 to 21 and 19 to 21. Now a coordinate bench has taken note of this fact and has recorded Now, now,
Under the
And on
sun,
that basis, interim order given.
now, an interim order given.
Interim
Now,
order.
if,
the order, my lord, if I may ask myself, my lord,
now,
order, my lord.
whether it would be
Will abide by the result. The order not.
I just try and find out, my lord.
that in that circumstances, it would be that I am sitting out in appeal over this.
My lord, after this
Mr.
writ
Ray, you have
petition,
to
my
wait
lord,
your
after this writ petition, my lord, there is this amendment application. Now, my lord will kindly consider that your lordship has been now facing with an amendment application. It does not matter what your lordship's predecessor has held, because he has not considered the amendment application. Right? So, my lord, in that event, my lord, I should get the right of filing an opposition to the amendment application when it's moving it. It's like, my lord, allowing an amendment in a suit without the defendant getting a chance of opposing. So, my lord, I should get that opportunity, one. Second is, my lord, I'm taking the point, judgment. I'm taking the point that, my lord, he is not entitled to change his case in the manner he's trying to do, my lord, after, my lord, by way of a supplementary affidavit. Your lordship will kindly see the writ petition. The writ petition is absolutely clear. It's on the point that I couldn't have done it, made it as an NPA because of certain corresponding letters. But MSME point was never taken. So now, my lord, kindly see the supplementary affidavit. Your lordship will find it's only about MSME. A new point. Now, your lordship kindly takes, my lord, this is 2003-4, Company Law Journal 333, my lord.
2000?
2003-4, Company Law Journal 333.
33. Yes.
I will kindly take paragraph 33. My lord, this is by the division bench, my lord.
May I say this? In this case, my lord, I was there in this matter.
Thank you.
My lord, in this case, my lord, what is implicit in a challenge to 13.2, my lord, is declaration of NPA. That was taken into consideration. On that basis, writ petition entertained, interim orders passed, and formal amendment application also filed to put in a prayer by abundant caution. That should be allowed, my lord. I don't know why my learned friend. And, my lord, please see page 7 of the writ petition. It's challenged. My lord, I've said your petitioner states, although litigated solicitor granted time to the petitioner.
Okay, you are protected by an interim order. Let them come with their response and affidavit.
My lord, in the meantime, they'll take further steps. Kindly allow my amendment.
Abide by the result.
Yes, but my lord, kindly.
Abide by the result.
It's true.
Ah.
But kindly,
My lord, where is
my lord, amendment can be allowed.
my lord, this is finally
Yes,
where
my lord, what is he saying?
Okay, okay. Since they are saying that they have the right to deal with the let them come with affidavit and their response.
Just 1 minute, my lord.
I am taking it on record in the circumstances. Otherwise, I shall not be able to invite your response.
My lord, keep it on your record, but does not take it on record. It's subject to
My learned friend can't do this.
My lord, kindly read the
Supplementary affidavit as filed on behalf of the petitioner be kept with the record.
kept with the but
Acha. The respondents,
decided by your lordship,
the respondents are at liberty to file their response to that supplementary affidavit.
including the maintainability of filing thereof, my lord, kindly, my lord.
Huh?
My lord, may I just kindly seize, my lord,
Take whatever
my lord,
point you want
kindly
to
seize
take.
this, my lord.
Now
May I
your
just-
lordship
my lord,
will
may I
have
just
to in
seize-
the order.
Acha, acha.
What he
Okay, okay, okay. When you will file your response?
7 days.
After the vacation.
7 days.
Lord, let them file by, my lord, the reopening day, and we'll come back.
That we can.
Lord, we'll come back on the reopening day. Lord, there's a lot of urgency in the matter.
My lord, where is the urgency?
He's
My
only
lord, where is
taking
the interim
technical
order?
points.
My where is the interim prayer, my lord?
I shall, I have circuit bench. I am to go from 23rd. I shall be.
My lord, I'll be on
Then
the
23rd. 23rd, we shall come.
24th.
Acha,
24th.
Acha, 1 week after the ensuing summer vacation. I stop. Acha. 1 week. Acha, থাকবো আর দরকার নেই আছে। এইবার আপনি লিখুন যে the petitioner has also filed an application for amendment of the writ petition. Stop. আচ্ছা, Mr. Royal and it Yeah. Advocate has shown রিপিটিশনের অর্ডারের কপি গুলো কোথায় গেল?
I'm appearing for the bank, madam.
আচ্ছা আচ্ছা, for the respondents, আচ্ছা, pays for leave to file their affidavit in opposition to the application for amendment. Stop, let such affidavit in opposition be filed within a week after the ensuing summer vacation. Reply, if any, be filed, they have to be filed within a week thereafter. List the matter for further consideration on 23rd ফাঁকা হবে on 20 ঠিক আছে, on 23rd June 2000 না 2022 not up to
21.
ঠিক আছে, আচ্ছা, the point of acceptability of supplementary affidavit is kept open.
And also, my lord, before, my lord, the hearing takes place, my lord, they should not do something to render everything
Which application
infructuous.
may I ask?
Otherwise, the hearing will be
Madam,
gone.
which application, my lord, may I ask?
Petition.
Madam,
Oh,
he
writ
said he
code
has
has
a final
power.
hearing. He has not filed any reply. He's asking for an interim order. Madam, how can that happen?
Let's
Which
ha-
application?
Let at least something.
Actually, Mr. Chaudhary, you should have prepared that they will come with this plea.
Not for 4 years,
Yeah.
they have not.
Because of the fact initially you came challenging the earlier 13 notice.
And all suppressed.
Thereafter you changed.
No, but my
You
lord,
yourself changed
my
the.
lord, may I say this?
Suppressed?
My lord, when we move, switching off the mic, but when we moved, my lord, it was converted really to an action challenging the NP as both orders record,
Madam,
and they've never
Madam,
objected.
my learned friend has refused to go over that side, madam. He should have. He should have. Because he knows what the judge was saying.
Yeah, I never got a chance.
But he did get a chance.
No.
He's nice.
Just show some records to show that what you're saying is right. There's no record to show I had a chance.
Okay.
Milord, but they should not render the writ petition infructuous.
How can that happen?
Very well, record that it won't be rendered infructuous. He says, how can that happen?
Well, your
Milord,
lordship is
he
here.
will not.
Court has already stated that a coordinate bench has taken note of.
Milord, kindly repeat that once, Milord. Kindly repeat that once.
No repetition is required. It is already on record. Okay, already on record. Already on
Milord,
record.
say that a coordinate bench is already held. Milord, that is all. That, Milord, the bank will then not do something.
He will not allow all these things. But
Okay, yeah. Abide by the result of the repetition.
Abide by the result.
kindly, madam, that should go down. But I don't understand, madam. Where is the
Oh, he's trying to incite you, and you are also.
No, he's not angry.
No, madam.
He's not angry.
Madam, these are such
His temperament is very good.
Some decorums which should.
I am following.
The decorum is, my lord, when there
To
is-
avoid an interim order, I'll keep arguing. Milord, kindly, Milord, record that there is a previous order which records.
No record. No requirement.
Milord,
There
kindly
is no
reiterate
requirement.
that.
There is already on record. Court has not passed any order. Only has given them liberty to file come with affidavit and response to your supplementary.
which has been moved today is the amendment application.
Milord, till then, they should not do anything. Who is, Milord, let's look at it this way.
Which
Oh,
4 years.
your junior asking a specific interim order. Interim order is already there.
provision are they asking for this?
Yes.
Which application?
Provision under the writ code.
Okay, go
Milord,
elsewhere, other matters are there.
Exactly.
Waiting for you.
Milord, in view of the fact there's already an interim order, nothing further is necessary. At least say that.
No requirement, no.
Very well.
No requirement. Okay, no requirement. Hey, call the list, call the next.
Okay.
Okay, call the next matter.
Just for order.
Milord, he has successfully disturbed me. He's not
Yes.
permitted me to argue.
Yes.
On next day, Milord,
Yes.
kindly pass an interim order.
But on the next day, kindly dispose of the writ petition by dismissing it.
Okay.
Item number 11, I am for
Yes.
I am for the petitioner.
Yes.
On the earlier occasion, your lordship was pleased to direct the council appearing for the information
Lordship,
commission.
Mr. Shondiban Banerjee is appearing on behalf of Howrah Municipal Corporation, Lordship. He is engaged in court number 11, Lordship. So can you please allow us a short.
The FPI, your lordship, the second appellate authority is the answering respondent here. And on the
Wait
earlier,
for 1 day accommodation, Lordship. And I need to receive the instruction, Lordship. Kindly take it up tomorrow, Lordship.
First is the urgency. Can it be after vacation?
Yes, Lordship. I have no problem.
Lordship, the petition is aged.
What is the matter?
Lordship, for last 5 years, your Lordship, there are certain second appeals which is pending.
Yes, sudden?
Certain second appeals which is pending.
Oh.
Concerned,
Oh, second appeal, Right to Information Act.
Yes,
yes,
Lordship.
yes.
Oh, 19.3.
19.3.
You are for the commission.
I am for the commission. I'll kindly take it up tomorrow.
To
Lordship.
dispose of the appeal.
We disposed of, Lordship. I am the verbally instruction, Lordship. The all appeal has disposed of, but I need to be written instruction from my client, Lordship.
So
Kindly take it
disposed
up
of,
tomorrow.
I am keeping it after vacation. You come with your documents
Yes,
to
Lordship.
show that all the appeals preferred by the petitioners have been disposed of.
Lordship.
Okay?
Lordship.
Come with the documents. Hey, I'm not after vacation. Okay. Please. No, hearing it. Hearing it.
After vacation.
Item number 12.
I am for the petition.
তবে ওই দিনে যেন হয় ওই দিনে যেন নেওয়া যায় এরকম একটা রিটার্নেবল মেথডে দিয়ে দেবে হ্যাঁ
But I am for the petition.
I pay for.
Yes.
Person to your director.
Item number is 12.
I pay for respondent number 4 bank.
Oh.
Your direction, I am filing this supplementary affidavit. And I have sought for that purpose. I am
Seeking
the affidavit service. I am filing the affidavit.
to provide bank statement of the credit card.
Where relief sought for is
Against the Axis Bank.
And I am filing this writ application only to seeking.
it rises out of a private contract between the parties with regard to the credit card, my lord. I respectfully submit that the writ petition should not be entertained, my lord, because it's related
Yes.
to
May I say-
How Axis Bank or any action done by a private banks can be amenable to the jurisdiction?
I am the customer of the respondent bank. So I have 4.
I have understood. Since you are customer, you have filed this petition. The question which has been raised by him regarding maintainability. How this petition is maintainable?
To their inaction or illegal act, I have made complaint before the Reserve Bank of India through Ombudsman scheme. That was not taken any steps. That is why I filed this application. It was filed. 14
Have you made the ombudsman as party to these proceedings?
Yes, my
Ombudsman, Reserve Bank.
respondent number 2 and 3. 2 is the RBI and 3 is the.
What is the procedure in respect of here to file an application before the ombudsman?
Kindly comes to page 25 P8 and except P8. I have made complaint before the RBI.
Oh, in this way you are.
Before that, I have made several representations to the bank as well as the authority, but no steps are taken.
Where is your? You show the provision of or act. So in respect of transaction of every credit card issued by a private bank, writ court is to intervene.
Lordship, I have two-fold submission in this regard, my lord. His petitioner's dispute is that there is a credit card issued by Axis Bank against that credit card on a particular date. Petitioner made a payment of rupees 77,000 through Paytm. However, the bank has not received.
I am not applying its mind regarding the dispute.
My lord, this is that.
Now I am still considering whether the writ court
maintainable, my lord. Because this is
could enter into such dispute or not.
Arises out of a private.
Where is the where you have written the ombudsman? You have just made a party ombudsman. Where is the yes? Show us what is the rule. Where is the provision that in case of a private bank you are? Where is the?
This is the Ombudsman Bank Scheme, 2006.
Now, writ petition where you have approached the ombudsman.
My lord, I'm sorry.
Show me the scheme. Which the scheme? Under the scheme, ombudsman operates or functions. Okay.
I have made complaint.
Where is that complaint? Before the ombudsman?
Clause M. So others is the.
Scheme called. To have a complaint before the ombudsman representative. It's not in my copy, if it's there. There is no representation before the ombudsman. Where is that? It's not there.
Where is that representation?
In my copy, it's not there. I don't know.
My copy is also not there. Where is the representation?
As per scheme, I have complained the annexure P8 through online. There is a system at that point of time. So I have made
annexure
P8, page 25. Kindly see all the details there. Find the case of 2020.
Here I have find a page 25, one complaint number. The before, whether it is before the bank or before the ombudsman, you show that before ombudsman, you made a complaint as per Reserve Bank guideline or Reserve Bank manual.
This is the complaint through online process.
What is the word ombudsman from this complaint you show? It may be before the bank authority.
Bank of Authority, I have made several representations. Lastly, my lord, kindly comes to page 33.
In this way, a complaint is made before the bank of ombudsman. What is the procedure is followed?
Reserve Bank
Yes, Reserve Bank
Before
is
the
okay,
bank
but-
ombudsman?
But usually, I'm not aware about the online format cases, but usually a complaint in the form of representation is given to the ombudsman. On the basis
Basically,
of that, on the basis of that complaint, the other party, the bank is called upon to give answers to that.
Thereafter,
You are now alleging inaction on the part of a particular authority.
yes, my lord,
There was a judgment of the Supreme Court. Before making this allegation, you have to approach this authority. That I have done it, I have raised some grievances before you, please address these grievances. Otherwise, I will make complaint before the jurisdiction citing your inaction. That you have not done the proper job imposed upon you by the statute.
But well, kindly come to see. Kindly come see.
You file afresh. Okay. You withdraw and file afresh. File afresh. You made a representation before the bank ombudsman.
Give direction on the basis of that.
I am not satisfied. You have failed to show that you have lodged any complaint. One complaint, it is not clear that this complaint was lodged before ombudsman. Even not a single representation that this complaint was lodged on such and such. You should have, under the statute, you should have entertained that complaint and take decision on it, but you have not done it, and hence, alleging inaction, I am approaching the jurisdiction. You are authority, public authority, so I am going. You should make out this case. Otherwise, may I filing here? No, in this way.
Representation, page 33, through learned advocate, narrating all the documents.
Order from the rich court is not a bounty. I am asking, so court will give.
I'm just
You
seeking,
have to make out a strong case in your favor.
this was my complaint.
Huh?
I'm just
You
seeking
show that you have made a complaint.
page 33, through learned
Page 33,
of this writ petition.
learned advocate letter.
That is the last.
Whether it can be stated to be a petition or representation. It's a threatening letter. They do it, otherwise appropriate legal action shall be taken against you. Huh? So let him approach the.
In terms of prayer, my lord, I have no objection if any direction upon RBI is given to consider to take up the hearing of the representation. But apart from this, the other reliefs which the petitioner has sought for taking action against the bank, these reliefs I am opposing, my lord. This cannot be granted in this.
After filing of this writ petition, I have overdraft account and mortgage some of my mutual funds. That was withholding still now. So these are distinctive in nature. Instead of that, they have withdrawn my overdraft facility only for this dispute since 2020. And I have made in supplementary affidavit.
You come to procedure 9. 9. It is paragraph 9. Complaint in writing shall be duly signed by the complainant or his authorized representation and shall be as far as possible in the form specified in Annexure A. You show. Stating clearly name and address of the complainant, name and address of the branch of office of the bank against whom complaint is made, fact giving rise to the complaint, nature and extent of loss caused to the complaint, and relief sought for. You showed this complaint in terms of paragraph 9 of this manual or the scheme, was lodged with the jurisdictional ombudsman.
This is the online format, so I have mentioned all.
Why online format? Online format, this is not, manual does not say so.
No, not yet done, it's true. But this is the, I have made complaint on the basis of that, my lord, kindly, if the writ is dismissed in the meantime, then I will get nothing.
In the event it is filed,
Dismissed.
you show us that, you show me that this complaint was filed.
Into that reason, they have.
File afresh, withdraw and file afresh. Huh? Withdraw. Acha. The writ petitioner pays for deed.
Number 13.
In 13, Lord, I appeared for the Respondents Union of India. On the last occasion, Mr. Noyan Bihani, senior advocate, appeared for the petitioner and made his submissions. Now, Lord, I was not present on the last occasion. Now, Lord, one order has been recorded. If your lordship kindly see the last order passed by your lordship.
Yes. Petitioner is directed to serve a notice.
Yes.
They have not served any notice.
No,
Okay.
I had a talk over phone. So I could not be present on the last occasion. Mr. Bihani made his submissions in support of the writ petition. Now, my lord, your lordship has recorded that the affidavit in opposition was not on record. My lord, that is with me. My lord, let it be kept with the record. Reply has been filed.
The affidavit in opposition as filed on behalf of the petitioner is taken on record.
Respondents.
Today, the petitioner is repented, unrepented. However, to afford another opportunity of hearing to the petitioner to appear and contest, please the matter for further consideration on 24th June.
24th June. Not any Monday, if possible. Not any Monday.
Monday. So 30th June.
30th June.
30.
I'm grateful to. That opposition has been filed on behalf of the respondents.
On behalf of respondents, yes. Affidavit in opposition on behalf of respondent বলেছি। Yes. Yes.
I'm grateful.
Yes. Oh.
14 না 15 আমাদের কত?
I am appearing
Well,
for
I
the
am for the
respondent
petitioner.
number 3. Well, the answering respondent is the state.
My lord, and for the state, my lord, Mr. Ganguly is appearing in this matter. There was a direction for filing opposition, my lord. My lord, we'll pray for some more time to file the opposition.
Well, this is second time, third time. First time the matter was moved on 22nd of March 2024. Order was passed for passing for direction for filing affidavits. Then your lordship passed an order on 10th of April 2005. The lordship's order to file affidavit in opposition. They have not filed. That is your lordship, whether your lordship will allow further time to them. Twice this court directed.
Twice by this
court. Well,
twice means on 8 April 2024, they have filed. Respondent number 3 filed.
Well, I have filed.
Now, on 10th April, they prayed for most
and you
probably
allowed
state,
them to file a bill of opposition.
it is Mr. Ganguly appear.
With Sisanda Bandyopadhyay.
On 22nd March, liberty was given to file affidavit in opposition.
So twice given.
Finding 7 more days may be given, madam. We'll file the.
Then the vacation is intervened.
Kindly keeps it after vacation at the.
I am to give reply.
Yes.
আমি দিয়ে দিচ্ছি আপনাকে হ্যাঁ হ্যাঁ
No, the affidavit has been exchanged by
yes,
Mr. Mukherjee and Mr. Petitioner is on record.
Yes,
On 8 April, yes. You are respondent number 3.
Yes,
yes. That part is complete. Now state is on.
My lord, kindly one more chance.
Your name, please.
My lord, Usha Poddar, my lord. My lord, panel, my lord.
Not in the panel.
I'm not in the panel. I'm junior of Mr.
He is
Ganguly.
not in the panel. He is junior. He is very well, man. I'm not.
Mr. Satan Sir, learned advocate appearing
I'm grateful, man.
Yes.
Hello. Hello.
আমি আপগ্রেড ম্যাটার হ্যাঁ
Item number 18.
Lord, I have served, my lord, the earlier occasion, my lord, pursuant to your lordship's direction, my lord. They are not appearing, my lord.
ওই জন্যই কিছু ফাইল নিয়ে গেছে যেগুলো পড়বেন সেগুলি হ্যাঁ ঠিক ঠিক
Lord, pursuant to your lordship's direction, we have served again, but my lord, nobody is appearing for the state.
মিস্টার সিদ্দিকী
My lord, the facts of the case is very short. My lord, mining lease was executed in my favor. My lord, then, my lord, suddenly the problem cropped up. My lord, if your lordship kindly comes to the mining lease deed, my lord, at page 2017, my lord, it was executed. My lord, at page 24. My lord, the relevant portion is, my lord, at page 60.
দ্যাট ম্যাটার বর্ণরেখা নয় ইট ইজ এ ডিফারেন্ট
It is different. My lord, page 24, my lord, on 10th of February 2017, my lord, the mining lease deed was executed. If your lordship kindly comes to page 60, my lord, this is the map appended to the mining lease.
পেজ
60.
60
60. Lordship kindly takes note of, my lord, MGB 44. This is my plot of land, my lord, which I was allotted. Lordship will find, my lord, the access
Yes,
road,
yes.
my lord, over Suvarnarekha River. Lordship kindly sees the access road has been specifically, my lord, there, my lord, the bridge. My lord, we have constructed a bridge over there. But, my lord, subsequently what happened? My lord, this was, my lord, the clear, my lord, misrepresentation on the part of the state authority. My lord, they, my lord, submitted this plan on the basis of this, my lord, mining lease was because there is no other, my lord, way, my lord, to access, my lord, the plot of land where, my lord, the mining, my lord, operation will be conducted. Now, my lord, what happened, my lord? Subsequently, my lord, the National Green Tribunal, my lord, passed an order, my lord, directing us, my lord, to remove this bridge because it was over the Suvarnarekha River, my lord. We had to remove the bridge, my lord. We have accordingly, my lord, removed. Now, my lord, the problem is that, my lord, post, my lord, removal, my lord, we just operated, my lord, this mining operation for, my lord, 6 months only. My lord, post, my lord, removal, my lord, we are not getting access to this land. Now, my lord, the state authority, my lord, filed an affidavit in opposition to this writ petition. My lord, probably this is in the file. If your lordship, my lord, they have served us.
No affidavit in opposition.
Then, my lord, I have a copy of this, my lord, opposition. If your lordship kindly considers this, they have also admitted in their opposition.
Have you filed a reply?
Yes, reply, my lord, taken on record.
Reply. Yes, reply got with affidavit of such.
Lord, kindly excuse
They
me,
have
my lord,
not
this is,
filed the affidavit in opposition.
Lord, lordship, kindly excuse me, this opposition is marked, my lord. This is a marked copy.
Okay, in the affidavit of opposition, they have admitted that
They have
you
admitted, my lord.
constructed one beach.
Yes, if your lordship
they
kindly
have-
considers, my lord,
Thereafter,
paragraph
following
11
the
and 12.
order of tribunal, you have removed the beach. Now we are not getting access to the to the land.
Yes, my
To
lord,
extract sand.
page 11 and 12, I would be requesting your lordship kindly considers. Page 11 and 12.
Of
The opposition, my lord, which I have handed over to your lordship. My lord, paragraph 13, lordship, kindly have a look. Page 11, paragraph 13. My lord, the allegations have been denied, my lord, at seriatim. Then, my lord, lordship kindly considers. It is humbly submitted that even after removal of the bridge over river Suvarnarekha, in compliance of the order passed by the Honorable Tribunal, the petitioner has road connectivity available for such mining activities connecting Rontua to Feko and Rontua to Noyagram Road, which has been used by the other lessee of land, block MGB 45. You know, this is my adjacent plot. So, you know, there is a availability of road situated on the same plot number 2488 as that of instant appellant's sand block MGB 44 in the same Mouja, Ashkola, jail number so and so, block Gopivallapur 2. So, my lord, my humble submission is only this, my lord, since they have also admitting, my lord, they are also admitting, my lord, this, my lord, road should be, my lord, they should allow us, my lord, to use this road because this is the adjacent road. But, my lord, since, my lord, the release date is mentioning, my lord, at page 60, I have seen, my lord, I have shown to your lordship, my lord, the specific road, my lord, they have mentioned, my lord, over the Subarnarekha river, which has been, my lord, the bridge has been removed, my lord, by virtue of, my lord, honorable tribunal's order. So, my lord, I cannot access that road. So, my lord, I am just humbly beseeching your lordship, kindly, my lord, allow us, my lord, to use this road. My lord, this road, my lord, is being used by the adjacent plot holder. If your lordship come back, my lord, to page 60 again, my lord, may I just take your lordship, my lord? Page 60, lordship kindly sees, my lord, MGB 45 is the adjacent plot.
Yes.
So, my lord, this road, my lord, which is adjacent to this land, my lord, they are accessing, but my lord, we are not being able to access since, my lord, this particular, my lord, obstruction has been created. My lord, now if your lordship kindly considers, my lord, my lord, section 108 of the Transfer of Property Act, my lord, it is the lesser's duty, my lord, to keep me in possession. Lordship kindly sees 108, my lord, for a moment. My lord, clause A, lordship kindly sees the lessor is bound to disclose the lessee any material defect in the property. My lord, here they have not disclosed. This is
What they have not disclosed.
my lord, the material defect is, my lord, as per the mining, my lord, as per the site plan which they have provided, they have shown, my lord, the bridge over the river. But they have not disclosed that we cannot construct bridge over the river. My lord, this is the material defect in the lease itself. Now, my lord, they are taking the plea that no such, my lord, road cannot be constructed. Lordship kindly sees, my lord, clause B thereafter. My lord, the lessor is bound on the lessee's request to put him in possession of the property. So, my lord, I just beseech your lordship kindly allow us, my lord, to access, my lord, the road, my lord, which the adjacent plot holder, my lord, is using. My lord, this is my short and, my lord, submission
Sum and
before your
substance
lordship.
of your case.
Yes, yes. My lord, this is the only case, and they are also admitting in their affidavit in opposition, my lord. Lord, they have, Lord, obstruction, Lord, they are creating obstruction in respect of the access road over Subarnarekha river. I understand, Lord. Since there is an, Lord, order passed by the Honorable Tribunal, Lord, I do not want to do that. I have, in fact, Lord, removed, Lord. The removal has also been, Lord, recorded in their opposition. Milord, I have removed, Milord, just before, Milord, few lines before paragraph 13, they have also admitted that in compliance of the order of the Honorable Tribunal, the temporary bridge was completely removed. This removal was done, Milord, at my client's instance.
Despite service, the state is unrepresented. Stop. This present petitioner was paper primarily playing for the following reliefs.
Next matter,
Oh.
item number 15.
Or in the next matter, next 12:30. Oh,
Next matter, you are there.
Yes.
Who is your other side? Oh, so next matter টা করিয়ে নি নাকি? You wait and let the next matter be completed. What is the matter, Mr. Ghosh?
But a matter relates to higher.
May I file my
Scale of
opposition, my lord?
Can be disposed of now or?
Yes, yes.
Oh.
No copy has been served upon me, the opposition.
Opposition?
Every in opposition?
You to reply file করেছে।
Reply opposition.
I think he has filed a reply.
Oh, sorry, sir.
He says sorry. Affidavit
The
was-
affidavit exchanged by the parties, record in.
I'm
Are
sorry.
taken on record.
আমি অন্য
Affidavit
কথা-
exchanged by.
Of my reply.
To release the benefit of honors graduate scale to the petitioner with effect from the date following the geography. Oh, that higher scale of pay.
Yes.
Yes.
Okay, you are appointed to honors and PG category.
I've appointed as a past graduate category. But if you kindly come to page 70.
So Utpal Chandra Karan is not applicable to you.
It's applicable to me also.
Achha,
But
okay.
if you also kindly page 70.
Page 70.
The earlier order of this honorable court. Page 70.
Page 17 of?
70 of the report.
70, oh. Yes.
Well, this writ petition was filed by me in 2009. Where before filing of this writ petition, I moved to another writ petition. This honorable court directed the DI to consider my representation. The representation was rejected on the twofold ground. But if you also kindly see the ground, page 72 is the ground for rejection.
Yes.
The first paragraph, the staff pattern of the concerned school did not permit granting of above benefit to the petitioner. 2. The petitioner was not entitled to get postgraduate scale of pay in view of the West Bengal Control and Expenditure Act 2005, as well as in terms of GO number so and so. Number, I challenged this observation of the DI rejecting my prayer by the earlier writ petition filed in 2009.
Okay.
But this honorable court, after hearing me and in a elaborate judgment of almost 10 pages, if your lordship kindly come, page 77.
Yes.
Gautam, kindly come to last,
Respondent 3 was directed to extend the benefit of honors.
Yes. I have been, this honorable court, please to direct the respondent number 3 to give honors graduate scale of pay from 30th October 2005. This order was not challenged by the respondent. Never challenged by the respondent.
That has not been given.
That has not been given.
You didn't file any contempt application?
I could not file any contempt application.
Within the time against you have
I filed this present writ petition for granting of the suit.
to enforce this order.
Yes. Now, firstly, the writ petition, the earlier order has been came into finality because no appeal has been preferred. Now, I filed this writ petition for implementation of this order. Which has already been settled by the earlier judgment.
Yes.
Lord, this, if your lordship takes the impugned order, the impugned
There is no
order.
impugned order.
No. Kindly have a look to my opposition. Page 9, R1.
Yes.
Lord, this is an order passed by the additional director of District Hospital Schools, Secondary Education, Kontai. If your lordship takes the last penultimate paragraph, the relevant portion I am placing. Thus, I, the additional District Hospital Schools AC, Kontai subdivision, have gone through the papers and documents submitted before me and verified in toto. And after the verification of the papers regarding the claim of the petitioner, I am of the opinion
that Sri Jana is not at all entitled to get honors scale of pay as he was basically appointed as past graduate and in terms of GO number so and so dated 4th September 98, out of 3 teaching staff in social science group, 2 posts have been filled by honors stroke PG candidates except Sri Jana, and Sri Jana therefore may not be allowed honors scale of pay in terms of clause 14 of West Bengal's Control of Expenditure Act 2005 read with GO number so and so 2007. Now, my lord, this
order has been set aside by the earlier judgment passed by this court.
Yes.
Around 23rd September 2016, this order has been set aside.
Now, my lord, here, my lord, here, my lordship, kindly have a look to the order to set aside. Now, my lord, if your lordship comes to page 3 of the opposition, paragraph D or paragraph 5 at the bottom.
Yes.
Petitioner's claim was rejected by the ADI of a school's secondary education contest subdivision in the said reasoned order with a memo number so and so dated 21st August 2009 as because the petitioner was appointed as past graduate teacher and 2 teaching posts of social science group had already been filled up in the said school. Thus, in terms of GO number so and so, petitioner's prayer could not be accepted. Now, my lord, this is the order which is annexure R1 to the petition. Now, my lord, this learned friend says that this was set aside. It is set aside as
Dealt with and it challenge করেছিলাম আগে. If your lordship kindly see my learned senior friend's affidavit in opposition, page 5, paragraph 10. In paragraph 10, in opposition, they have dealt with paragraph 17, 18, and paragraph 11, they dealt with paragraph 19. Kindly see what they have said. I have no comment regarding the statement made in paragraph 17 and 18 of the said petition. The allegation made in paragraph 19 of the said petition are denied by me, 7 actors who entered the matter of record. I reserve my right to make appropriate submission at the time of hearing.
Yes.
Now, let kindly come to my writ petition, paragraph page 9.
That earlier petition
Yes.
at that
They have not denied. They have not said that this order has been set aside or quashed.
But I find, my lord, in the affidavit in opposition, but there is a gap. My lord, if I may, my lord, come with a supplementary affidavit or supplementary file করতে উপায় নেই।
At this stage, but this affidavit in opposition, nothing has been stated regarding the earlier order. They simply proceeded that the impugned order of the ADI.
Oh, okay. Gain benefit in terms of that. You have allowed the order to attain this finality. Now you can challenge. You cannot challenge
That is there.
at this stage.
That is there, but they did not take out any contempt petition for that reason.
Maybe they have has come.
Lord Lordship kindly sees the prayers.
One lawful order passed by a competent court of law cannot be allowed to be frustrated.
Yes, that's what the law says.
Yeah, law says so.
Now, here,
So you give. What can be done?
Lordship, my lord, the order of Justice Chatterjee is there. Still staring at the face that that order was not challenged. That is admitted position. Now, my lord, that I know, my lord, there is a judgment of 2007 which says that a fresh disposition is maintainable for implementation of an
Enforcement
order.
of the order.
Yes, that is two judgments I know. I remember right now. So, my lord, to that one I cannot possibly oppose. But, my lord, Lordship, kindly 1 or 2 paragraphs let me place and
Yes.
opposition.
Yes.
Well, these are all, my lord. Even then, my lord, I kindly have a look tomorrow, page 5 once.
Yes.
Paragraph 12, page 5.
Yes.
Subpara 3 of para 12 of GO number so and so dated 12 February 2099. Reads as follows: all teachers, including physical education teachers and librarians of secondary schools who have improved will improve their qualifications who were appointed with higher qualification in the subject or groups relevant to the teaching appointment shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later. Then, my lord, this has been annexed. Next paragraph, my lord, II. The set subpara 3 of GO number 25 dated 12th of February 99 was amended with a para 3 of GO number so dated 13 July 99 as follows. All teachers, including physical education teachers and librarians and secondary schools who have improved, will improve their qualifications or who were appointed with higher qualifications in the subjects or groups relevant to their teachings. The appointments shall get higher scale of pay appropriate to their qualification with effect from the 1st January 1996 or the date of improving qualifications, whichever is later, provided that, this is important, provided that such higher qualified teachers in the relevant subjects or group is justified as per approved staff pattern of that school. If such teacher is appointed through West Bengal School Service Commission, her pay will be fixed in the scale of pay as per this qualification mentioned in the West Bengal School Service Commission. Now, my lord, this part is important.
This point was also considered by the earlier honorable single bench in page 75. 75 and 76.
Yes, yes, it was there. Now, my lord, here, my lord, only one thing, my lord, I want to show. I think, my lord, the Control of Expenditure Act, Section 14. Lordship, kindly have a look. My lord, I have got only one book.
Subject to correction, the honorable single bench came into a specific finding that control of expenditure will not apply in my case because I obtained the A before the control of expenditure came into effect. That was the observation taken by the her ladyship.
Yeah, the NMC is going to be 2006.
My lord, he acquired a higher qualification in 2006.
No, sir, 2005.
No, 5.
Last date, 30th October 2005. When control of expenditure.
August 2000. Before that, I took admission. I took admission before that.
My statement, my lord, at page 7, it says, subparagraph 5, petitioner secured higher qualification in the 2006. That's a ভুল আছে তো তার মধ্যে, এটা ভুল। বড় বছর 2005 পর ঠিক আছে 2005
No, sir. Last date of examination 2005. October 2005.
Well, the statement here in subparagraph 5, petitioner secured higher qualification in 2006 after the introduction of West Bengal Schools Control Expenditure Act 2005. Now, my lord, তো আমাদের এটা
Board of Secondary Education filed memo of the sanction study leaves of the petitioner on 28 June 2006.
my lord, my lord, admittedly, my lord, he was given allowed a study leave in 2006. So how could he appear, my lord, secure of 2005? I am putting the question to myself. But in the list of dates, I find, my lord, that
it was post facto approval of my study leave in 2006.
The post facto. Now, my lord, the paragraphs, my lord, section 14 of the section 14 of the Control of Expenditure Act 2005 says, I just read one sentence. Every teacher of a school shall be entitled to draw pay in which he is appointed and shall not be entitled to claim any additional increment or higher scale of pay for acquiring any qualification other than the qualification specified for such post. But if your lordship takes a look to this, paragraph 1 of subsection 1 of section 14. Kindly have a look on it. Now, my lord, the law is this, my lord, that Here, the only two grounds. The first is, there are two posts in social science group. One is which are filled up by honors and postgraduate candidates. And he is only past graduate. So he, even if after this section 14, operates as a bar to his getting such and such. I don't think this
if you
was.
also kindly see section 14 subsection control expenditure একটাই বলছি।
So I think this section, with due respect,
Stand in the way.
and it was not duly considered, but this should have been in the form of appeal. But there is no appeal, but I cannot improve upon it. Whatever is there is there.
Okay.
Well, if you also kindly see the section 14.3.
14.3.
Yes.
Yes.
But if you also see the 14.3 says that this act will station, he was arrested, he was granted bail from the lower court on the Saturday. My lord, the problem is we have filed.
Oh, that is criminal division. So now he has got the relief.
Yes, my lord. My lord, this is pertains to a conviction order. We went for an appeal before the lower court. We lost. We preferred a revision application. In 2010, we have obtained the stay. The subsequent, the stay was vacated in the year 2021 because of dismiss for default. Last occasion when the matter was taken up by my lord was pleased to raise an issue whether a restoration can be under CRPC, whether a restoration can be done or not, my lord. My lord, to that effect, my lord, I'm going to make certain submissions. First of all, my lord, restoration of dismiss for default is not a judgment. So it does not bars me under 362 of the CRPC. A dismiss for default does not go into the merits of the matter, my lord. So at the time when the matter is not particular thing, all the things are not been taken care of, then my lord, a judgment is passed or whatever orders has been passed cannot be dealt in a manner that cannot be altered or that particular thing cannot be recalled because it was dismissed for default and the issues were not somehow addressed at the point of hearing, my lord. My lord, I'm somehow guided by few judgments of the other courts, my lord.
My lord, in this matter, I'm appearing on behalf of the opposite party.
What is served, my lord?
Copy be served upon me, my lord.
Yes, because let my lord admit the matter, then I will serve. It's a revision, sir.
What happened in the High Court of Allahabad?
Paragraph number 26 defines judgment, and they have laid down certain criteria under which the judgment should be passed and the criteria should be followed while passing a judgment. My lord, might kindly takes up paragraph 26.
My lord, without service upon me,
admission.
That is concerned about admission or recalling, whatever it is. You are bound to serve the copy upon me.
Revision before admission, how will I serve?
Yes.
Ask him to come.
Which admission?
Not been admitted as yet.
Yes, my lord.
No question admit. Recalling of the order, my lord.
I couldn't follow.
This is recalling of the order. No question admission. Recalling of the order, which matter has been dismissed. I am entitled to get and make the submission on that petition, my lord.
Unless the petitioner is admitted yet.
Petition already this recalling petition can't be admitted at this stage.
It is recalled but not admitted then.
Yes. So that the copy served upon me and file the opposition to that petition, my lord.
My lord, then
in this case, my lord,
admit and stay, give the stay and serve and come back.
Complainant file the
So I am recalling the order and I am restored the matter.
No, at this time, no. I filed the objection to that, my lord. To that, I am recalling the order and restore the application. That is to matter was dismissed 2021. The 2005, 5 years has been paid. What is the explanation is there?
Huh?
What is the explanation for 5 years? Why not come before your lordship earlier?
Our section 5 application. To condone the delay, what I have to explain why I was delayed. There was a delay in filing the restoration. That is a separate thing, my lord.
Okay, sir.
Yes, that is the only.
For the time, my lord, may stylist stay my.
No question stay at this stage, my lord.
Then he cannot come down without any admission of the matter. He cannot come down and serve.
What is admission?
What will I serve?
What is admission here?
Who will I serve?
There is no petition in the eye of law as on date.
Yes.
Yes, my lord. Then kindly hears me out with all this judgment.
As in yes, so he is seeking right of audience. He is seeking
right of audience. First, the matter has to be admitted, my lord. If the matter gets dismissed here, my lord, then his right of audience does not come into question, my lord.
No, in case a appeal is belatedly filed. If a appeal is belatedly filed, then a section 5 application is filed.
My lord.
Actually, appeal is not admitted. Even order 4111. So appeal has not been admitted. So whether he will get a right to audience in respect of section 5 application or not.
My lord, but
he has a right to oppose or not.
My lord, in revision
before admission.
My lord,
the appeal has not yet been admitted under order 4111.
My lord, then he has to be.
And there was a delay in preparing that appeal. Okay.
My lord, then here I restore the matter and I can serve him.
Without hearing the section 5 to be allowed, no
he wants the right.
He wants the restoration application copy then, my lord. That is what
actually when a litigant caused delay in approaching the court.
Yes.
Thus delay gives a right to the other side to claim that the order or action has attained finally. And unless you can justify your delay, he is entitled to enjoy the benefit of that finality.
My lord, now, my lord, I can kindly address this, my lord. I
So-
was enjoying an interim
So
order.
serve the application.
He was not, rather, he was in the difficulty. I was enjoying an interim order. I did not appear. My interim order was vacated. The matter
Yes.
was dismissed for default.
Yeah, dismissed for default by you caused
My lord, the
delay.
rest of the matter, I will come back with the
You
submission.
caused delay in preparing the application for restoration.
I understand, my lord.
This delay has given him a right to oppose your prayer for condonation.
I have not filed yet my section 5, my lord. I'm on simply on
Oh,
restoration.
that does mean you have
You want to jumping is there.
Yes, jumping.
you have not.
Jumping.
So you have not explained the delay. So there is
It has to be restored. Then we have the section 5 will be filed, my lord.
again you are saying so.
Yes, my lord.
Huh? Unless the delay is condoned, whether his application for restoration can be entertained.
Okay, my
You
lord.
are
I come
more
back with the
advanced. You
submission.
are the young lawyer of this age. Can handle tab, can handle more. Better than us.
That is different, my lord. But then but unless and until it's
Huh?
restored, my section 5
Serve the internet. You are saying so. So you prepare an application for restoration, serve the copy upon your let court is here. If there is a sufficient cause,
my lord, the cause
you have
another thing, my lord. I'm telling you, my lord.
you justify the delay.
Petitioner
Your
will never not be able to come and
petition
affirm.
will be entertained. Don't
The
worry.
predicament that I'm facing, my lord, the petitioner will not able to come and affirm because he's going through a liver transplant. He's a liver cirrhosis patient. On that particular ground, I was granted bail because he's flying.
That one thing in your the application for restoration, have you explained the delay?
Yes, that is delayed. That is there.
So show that application.
No question is this, my lord. How this recalling petition to be affirmed? My lord saying the point is there.
No, separate application.
Yes.
There is a judgment. Separate application is not always required. Court can entertain, but you have to explain the delay.
Yes, my lord. My lord,
Where
paragraph
is the
number
explain
5.
the delay?
Paragraph number 5, my lord. And delayed is not explained, my lord. Delay has to be
Either if you opt that I shall file a composite application, that is application for restoration as well as application for condonation of
Section
delay.
5, then I'm filing.
Then the explanation of delay is to be incorporated in that application, or otherwise you have to file two separate applications. One for restoration, another for condonation of delay.
If section
Liberty may be granted, my lord. Come back.
No liberty. Liberty
Section
will
5 to
be
file section 5.
subsequently liberty will be constitute that that it is primarily or it has been prima facie allowed.
Okay.
No liberty is there.
Fine.
You come adjourned as the petitioner press for leave to file to take appropriate steps in view thereof. Petitioner, learned advocate, depending on number.
as a candidate, but Narendrapur Ramakrishna Mission is reluctant, my lord, to accept me. I am in a no man's land, my lord. I have left everything of my Delhi establishment where I was working. I have decided to come back here, and my lord, the whole matter is dragged and dragged in this fashion, my lord. My lord, recommended by the college, he is here, my lord, my learned friend. If this is not able to kindly fix it tomorrow at a particular time, then my lord, I can bring the Ramakrishna Mission also.
কালকে কি আছে মানে বা কিছু আছে মোশন টোশন আছে নাকি আবার? এগুলো আগে দেওয়া যাবে। আজকে তো হলো দেখুন 19, এখন কি দুটোর সময় কি আছে বলুন তো?
It's concerned that is
হয় যদি I am trying to today up to 19.
Lordship.
Thereafter 8 matters. I am told 8 matters are to be.
20th.
If not from 20 and onwards যাতে টানা করে দিই আর কি। আর যদি কেউ আর্জেন্ট মেনশন করেছে কি? Okay, I am trying.
My lord, on 20th, my lord. I will effect service upon the learned other side of Ramakrishna Mission. College Service Commission is here.
Mr. Panda is there.
He is here, my lord. He is here.
He is
always.
College Service Commission.
He is college service. He has recommended my name. Yes, my lord.
So he is part.
But the college authority is reluctant to accept me.
Allegation, twofold allegation. Once of all, despite recommendation issued by the College Service Commission, the Ramakrishna Mission has not given any appointment. But second limb of service of my network.
Okay. Who is appearing for Ramakrishna Mission?
I will effect service upon them, my lord. The date may kindly be fixed.
Come after vacation. That would be
suffering because, my lord, what happened? I am a professor of, my lord, the Delhi University. But I have tendered my resignation almost.
Whether within 4 days it would be possible.
My lord, 2024 onwards it is pending, my lord.
Have they been? I could have just satisfied that after getting recommendation. Or
and second of submission of my
after recommendation made by the college authority, whether the mission has got any authority to refuse to accept.
Main allegation against me, I have made certain, my lord, the comments in the social media, as a result of which they are reluctant to accept me as their professor. They are considering me. I am against the ideology of Ramakrishna Vivekananda. My lord, I have made comments, maybe. My lord, that comments cannot stand on the way so far my right to life is concerned. And they did not enclose any document. What comments I have made? Maybe I have reservation. I am a Marxist. I have a reservation. Maybe. No bar so far my lord, my right of speech is concerned.
At the time.
But kindly tell me 20th, my lord, if possible, my lord.
20.
If possible, my lord.
Tomorrow আপনি উপর থেকে দিয়ে দেবেন যদি না কিছু ঠিক আছে।
If possible, my lord. I know, my lord.
কালকে আজকে ঠিক আছে, এটা 2 PM নয়, এমনি ফার্স্ট হাফই ধর। I'm trying to
item number 26.
Item number 26.
Okay. Before my lord, my lord.
He will take time for filing reply to my opposition. Item 20.
Okay.
So simply may I file the
আচ্ছা, item number 20 লিখুন তো। আচ্ছা, APP opposition on filed on behalf of.
My lord, I appear for the respondent number 8. I filed to opposition, my lord. I just selected candidate, my lord. Item number 20. I divided to
private respondent.
Private respondent.
আচ্ছা, affidavit opposition filed on behalf of the state. আচ্ছা, is taken on record. ঠিক আছে। Petitioner principal leave. আচ্ছা, I have been told that I have been informed that a copy of this affidavit in opposition has already been handed over upon the petitioner. Upon the petitioner. Acha, petitioner pays for leave to file affidavit reply thereto. Acha, let such reply be filed within a period of 1 week after the vacation, 1 week after the ensuing summer vacation. Acha.
Respondent number 8.
Acha, Mr. Sajansal Nanit advocate appearing on behalf of respondent number 8 pays for leave to file affidavit in opposition to the writ petition. Stop. Let such affidavit in opposition be filed within a period of 1 week after the summer vacation. ঠিক আছে। আচ্ছা, reply if any be filed within a week thereafter, list the matter for further consideration 3 weeks after the ensuing summer vacation.
My lord, before my lord rises with regard to
21 16 just देखिए 16 से you come at after recess, it would be next date. Who is the other side?
My lord, I am appearing for opposite party number 1.
Huh?
I'm for opposite party number 1, my lord.
Oh.
Item number 16.
I can hold my application. Can hold my application for extension. Last submission, pilot for extension. 17.
So I am extending the intimortal. Had the learned advocate appearing for the respective party leads the let the matter enlisted on 30th June. Until 31st.
With regard to
My lord, there is just one prayer, my lord. My lord, I don't have copy of the impugned judgment, so the petitioner be directed to supply a copy of the impugned judgment, my lord.
Impugned judgment. You have not served the copy of the it is annexed to in the with
It is not, there is no annexure to the
so
original
you
application.
have submitted without annexure, proper annexure.
Yes, my lord.
He will give. He will give. Okay, he will give.
With regard to item number 17, my lord, kindly recollect this is that matter of D Pharma College, your lordship, for granting of affiliation, my lord. The matter is fixed to that 12:30, but it could not be taken up due to paucity of time, my lord. If it could be taken up.
I have some difficulty in the second half. I am appearing for the Pharmacy Council of India.
Oh, in this matter. So come tomorrow. It would
Tomorrow,
be
Mr. Aniruddha,
tomorrow,
Mr. Aniruddha Chatterjee will not be available for us.
But then day after tomorrow.
Day after tomorrow, come.
The entire week, as well as.
But anyways,
For
in
the
any case,
entire
the
week.
matter has been settled by the Honorable Division. There is nothing remains in this matter, my lord.
Let me satisfy, my lord. Kindly-
You do it.
My lord, kindly
do
keep- my lord, Mr.
You
Chatterjee
are competent, man.
Mr. Chatterjee is there today, my lord. Kindly keeps it at 2 p.m.
But
or 3
second half,
p.m. my lord.
second half, I have some difficulties, my lord. I have some matter fixed.
You have heard second half eight matters. Some of your learned friend has their matter has been fixed.
My lord, then kindly keeps it at 10:30 tomorrow, my lord. With some precedence. my lord.
On the day also, my lord, I have submitted. It depends upon him, my lord's.
My lord, kindly keeps it at 10:30 tomorrow, my lord.
10:30, there's so much urgency.
You are seeking affiliation for
Yes.
the academic
Admission.
already.
I shall satisfy, my lord. My lord, kindly keeps it at 10:30 tomorrow, then, my lord.
এটা কালকে একটু উপরের দিকে
Similar, this
কালকে উপরে দিয়ে দেবেন
this question has already been settled. Again, is coming up with new application by another.
No, they are saying that you raise certain you pointed out certain deficiency of service.
Deficiency as per
In the
PCI
meantime,
guideline.
they have made all the
My lord, I am appearing for the PCI, my lord. The point has been settled by the division bench of this Honorable High Court. Whether affiliation of PCI is enough or affiliation from the examining authority is required or not, that point has been settled by the Honorable Division Bench of this Honorable High Court.
Okay, come with the judgment.
I shall.
My lord, then kindly keeps it at tomorrow.
এই এটা উপরে দিয়ে যাবে স্পেশালি ফিল তো কটায় দেবে আর নাহলে টু বি মেনশনে দিয়ে দিন যদি হয়ে যায়
It will not take more than 10 minutes, my lord.
So it will appear under the heading to be mentioned. ঠিক আছে আচ্ছা ইয়ে করুন তো দেখি আচ্ছা হার দ্য লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দ্য রেসপেক্টিভ পার্টি আচ্ছা লিজ দ্য ম্যাটার ফর ফার্দার
That has been now set at rest by the judgment of the lower division bench.
39.
Why has been now set at rest by the judgment?
Who is the other side?
Mr. Bhattacharya and Uttam Kumar Mandal.
That matter.
That matter. One of the point has been set at rest. I'll show you lots of judgment. That
You give notice. You give notice. Come tomorrow in the morning to mention whether and if it is not taken up. Okay. Yes.
Look.
In case the price of a product is reduced for any supplier due to invocation of price fall clause or any other reason, the same lower price shall also be applicable for the other suppliers who are having parallel RC running contracts for that item. If any supplier does not accept the lower price, Coal India Limited shall have the right to delete the item from the scope of RC of such form and procure explosive and accessories from other existing suppliers and reserve RC holders. Malab, this is they have applied in my case. I will take your losses. Malab, let me read with your losses again because this will be coming for consideration of you. In case the price of a product is reduced for any supplier due to invocation of price fall clause or any other reason. Malab, stop here, Malab. There, Malab, first, if any price of a product is reduced for any supplier, not Tom, Dick and Harry, he must be a supplier to the Coal India due to invocation of price fall clause. Now, suppose, my lord, I am supplying the same good with X. If X price fall clause applied and reduced, that will be applicable to me. It goes to like this. Or for any other reason. This is, my lord, according to me, say aegis dum generis. This will be clause like the earlier one. It can't be, my lord, any reason for whatsoever. It will be similar reasons for price fall clause. The same lower price shall also be applicable for the other suppliers who are having parallel RCs for that item. So therefore, Malad, the determination will be that both the persons or both the suppliers are having running contract for the same item. If it is not same item, clause cannot be applied. If any supplier does not accept the lower price, CIL shall have the right to delete that item from the scope of RC of such form. This is another clause, you'll also third condition. Suppose by writing I inform you, Coal India, you look, I'm not accepting this. Then Coal India, what will do? They will not accept my goods. What they will do in writing, they will inform me that I am deleting that item from your running contract. That much they can do. And procure explosive and accessories from the other existing suppliers or reserve RC holders. Well, they have a reserve suppliers from them. This is the scope your lawsuits, the provisions. Now, Malad, kindly come to Malad, page 83. Malad, kindly take note of this. Malad, this is of 30th November 2016. RC entered into Malad, page 67, 30th March 2015. So that almost 1.5 years after.
16.
Malad, the page 83.
83. Oh.
The notice given on 30th November 2016.
Yes.
At the top right hand side.
Yes.
And kindly, Malad, take note of page 67. RC Malad entered into offer was given to me on 30th March 2015. That means your lordships 9 months and 11 months. Almost it covers your lordships 2 years except 2 months. My running contract is for 2 years. Now your losses kindly see. Subject. Invocation of price fall clause against CIL RC number 30th March 2015. That's running contract. It has come to our knowledge that Mrs. Ideal Industrial Explosive Limited, Mrs. Ideal Explosive Limited Hyderabad Secunderabad, and Mrs. R. Genesis Industries Limited Secunderabad have accepted firm orders dated 2016 and respectively from Sinegarni Collieries Company Limited for supply of LD explosives and LD explosive cap sensitive / booster. So got then LD explosive non-cap sensitive / column to ACCL. That means, Malan, Sinegarni Collieries Company. My pronunciation may be wrong. Singaroni.
That will be Singaroni. For a period from 2nd May 2016 to 1st May 2018 at the prices lower than the price at which they are supplying to Coal India Limited against Coal India RC item with them. The comparison of price under, your losses can you take note of. First item number, LD explosive, cap sensitive booster. They, so for 16 to 16, 22 marks, 33,492. And so for 2nd May 2016 to the 30th March 2000. And this is your losses, LD explosive non-cap. Now, we would like to inform you that as per the terms of clause 7.1 of the CILs dated 30th March 2015, price fall clause will be invoked against the above mentioned three firms for the above items. We would also like to inform you that you being the parallel LC holder, having same prices for the above items, clause 7.2 of the RCL, which reads under is applicable in your case. Having same prices for the above items. But then they have quoted that clause 7.2. I'm skipping over, then you'll also. Considering the above, you are requested to supply LD explosive and a cap sensitive booster and LD explosive non-cap sensitive booster at ACCL's price 30,000 metric ton and rupees 27,500 metric respectively from 2nd May 2016 to 30th June 2016. The reduced price from 1st July 2016 to date will be communicated shortly. You are hereby given 2 weeks notice from the issue of this letter for implementation of the above price fall clause as per terms of the sale letter with intimation to this office and intimation to the ordering and paying authority of all subsidiaries of CIL. In case you do not accept the lower price, CIL shall have the right to delete these items from the scope of RC with CIL. This is the notice they are given. Well, I will argue what hours thereafter, but before that, your losses kindly take note of our reply to this. Very next page, page 85. Yeah. 19 December 2016. Well, this has a reference to letter dated, their letter dated 30th November 2016 at the reference. Then, with reference to your above letter, we would like to bring to your kind notice that we are not supplying any explosives to Messrs. Singareni Collieries Company Limited. And at the same time, we are not agreeing for the Singareni Collieries Company price for supply of explosive in future. So, Malad, we categorically intimated them, we are not going to accept your terms. So, at best, what they could have do, Malad, apart from without
remove the item.
Not, but before that, they have to show your lordships that they have complied, Malad, satisfied the conditions. Even that was not done. That I will argue. Next, we are going to supply the explosive as per Coal India Limited rate and not with the Singareni Collieries Company rate. But all that we told them that whatever we have decided according to our contract, we can agree to that. We are not going to agree to the rate of Singareni. This is for your information. Then your lordships, they have given another letter, page 86. It's not legible. Kindly come to Malad, page 86, capital A. Malad, there is one mistake in this copy. Malad, the date will be at the right hand side. Your losses probably in your losses will be also 2015. That will be 2017. If your losses can cross verify it from the earlier page, page 86. Though not legible. That should be.
Yes.
This should be Malad, 27th March 2017, not 2015. Page 86, capital A.
But 86 also 15.
I beg your losses?
86 also 15, 2015.
That's can't be your losses.
Okay, it would be treated as a 2017.
That should be. Now kindly see your lordships.
Yes.
Subject reference RC mean 30th March 2015. That means our running contract. With reference to the above, it is intended to extend the validity of the RC for a supply period of 1 month, provisionally to maintain continuity of the supply of the explosive and accessories at the existing rate and terms of the conditions.
That means they are not invoking the price plus cost.
That's your lordships. Kindly see, that's why this should be 2017 because it can't be 2015 because my first running agreement 30th March. It can't precede the preceding date. The final rates shall, however, be existing rate or the rates finalized against the tender number dated such and such, whichever is lower. This tender number I am not related to. This is tender number to third party. They are trying to say, your lordships, subsequent tender, they are getting lower price. Somebody is quoting lower price. I have to accept it. But my agreement with them relates to the previous date. This depends upon the rate of the product materials. Suppose I purchased at a high cost. I can't give you at a reduced rate. Today I am getting 1 metric ton at 1,000. It may be the reasons 2 years after the price has fallen. One getting 800. That's why he is quoting 800. It should be matching period, my lord. It can't be period to the earlier period. You can compare with the subsequent period. You are requested to confirm your acceptance of the same by return or mail positively by today, 27th March 2017. In case your acceptance or otherwise not received by the scheduled date, it will be presumed that the proposal is not acceptable to you and action will be taken without any further reference to you. Little bit of pause there for a moment. This is after our letter of refusing to accept their notice terms. Then they give me extension of the running contract at the existing rate. That means whichever we agreed to when we executed the agreement. Then the final rates shall have the existing rates or the rest finalized. As I find from the record, we have not responded to this. Correct? We have not. Now, we, according to earlier note, after their notice, we gave reply. We went of supplying. They went of receiving supplies. Even after this notice. Then your lordships, kindly see your lordship, the last annexure which is now being questioned before your lordship, page 87. 31st March 2017. Your lordships will find in the reference 3 dates your lordships will find. First, 30th March 2015, the date of running contract. Then your lordships, their notice, 30th November 2016. Then your letter nil dated 19th December 2016. But I am pointing out to this that they are aware when issuing this letter, they were aware of my reply also. So they must have applied their mind. Then they have issued it. Kindly, your lordships. I have to place it, your lordships. Through your notice dated 30th November 2016, referred to at serial number 2 above, you were informed that Mrs. Ideal Industrial Explosive Limited, Secunderabad, Mrs. Ideal Explosive Limited, Hyderabad, and Mrs. Regenesis Industries Private Limited, Secunderabad, have accepted firm orders, then order numbers, all dated 22nd May 2016 respectively, from Singareni Collieries Company Limited for supply of LD explosives, cap
and non-cap, yes.
And LD explosive non-cap to SCCL for a period from 2nd May 2016 to 1st May 2018 at the prices lower than the prices at which they are supplying to CIL against CIL's RCS with them. That means for the subsequent period, other suppliers giving to the other subsidiaries at a lower rate, and for that reason I have to accept the lower rate. That's their whole contention by invoking price fall clause of 7. By the said notice, you were also informed that as per the terms of the clause 7.1 of the CILS RC dated 30th March 2015, price fall clause will be invoked against the above mentioned three firms for the above item, and you being the parallel RC holder having same prices for the above items, the clause 7.2 of the Coal India Limited's running contract dated 30th March 2015 will be applicable in your case. You were given 2 weeks notice from the date of issue of our above notice for implementation of price fall clause as per terms of dated 30th March 2015. Then Malak, kindly see, very important. We have received your reply dated 19 December 2016 informing that you are not supplying LD explosive to CCCL and at the same time disagreed to supply LD explosives to CIL at CCL's price in future. So this is very categorical. They are not going to accept that price of CCCLS and at the same time I am saying that in future not even. However, this is to inform you that you have accepted the price fall clause of NIT while submitting your offer against the tender number 246 dated 30th December 2015, 14, that's page 27, against which the RC indicated at serial number 1 above was concluded. As you were supplying LD explosives to different subcontractors, even after issue of CILS notice indicated above two clause. Kindly pause that for a moment. I am not disputing here that clause is not there. That clause is there, everybody says. The two things I will be arguing before Lord is the scope of that clause, and if I say, my lord, according to the same clause that I am disagreeing, you can't go on accepting my materials and extend the contract also. And having done so, you say, I will not give you the price. In view of the above, the price fall clause, that is clause number 7.2 of your above referred RC, is hereby invoked so as to make the lower prices of ACCL for other RC holders applicable to you also. Accordingly, the price of LD explosives, cap sensitive, and the explosives non-cap sensitive of the RC stand amended as under for the period applicable thereto. Then your losses kindly see from 2nd May 2016 to 29th June, they have given according to their own. These prices applicable for the period from 30th March 27 to 30th March 2017 shall be communicated in due course. Then all other terms and conditions apply. Now, therefore, the two things I have to argue before losses: the scope of clause 7.2 and the second your losses. Even if your losses do not accept my submissions in regard to the scope of 7.2, I having refused or I having not agreed to give it reply, and if you go on accepting my materials thereafter, this shows that you have accepted my disagreement and you have accepted the rate which were initially entered into by both. That's it. Now, may I take your losses to that clause itself, 7.2. That's at page 70.
Yes. Yeah, yes.
Reply there. Oh, there was page just 19.
90.
Just a minute, then I will take you. Page 90. Because I'm placing the facts here. I'm sorry, I missed it. They wrote this notice at page on 30th March 2017. Our
Yes.
reply immediately thereafter, 4th March 2017. First, your losses kindly see that I have quoted the clause itself and the portion bold later. Kindly take note of this. If any supplier doesn't accept the lower price, right to delete the item and procure action. In our letter dated 19 December 2016, very next paragraph, we have clearly mentioned that we are not going to match Mrs. Singareni Colliery's Limited price. after 19 December 2016, we have received valid RE 11 indents from you for the supply of explosives. We have supplied the same as per your indent and not causing hampering of your production. Well, this is very vital because after giving our reply of disagreement, you could have deleted the item. Instead, what you did, you again issued the valid indent and accepted the materials. My contention will be, therefore, you have to give me the price at which we were agreed to initially. On 1st April 2017, we have also received extension of validity that I have taken to your lawsuits. Page 86, capital A. Of validity running contract for supply of explosives. This is, kindly see the varying dates. Almost your lordships 4 months I have supplied. From 19 December 2016 to 1st April 2017. There is no communication between either of the parties. So you have for the, at least, my lord, almost for 4 months, you went on receiving the materials by issuing proper valid RE indents. Then, your lordships, basing on the above, clause 72 is not applicable for us. We have not supplied any material to Mrs. Singareni Collieries Limited. And in the meantime, we have not received any letter from you that you have deleted from the suppliers list for not agreeing the lower price. But we are very categorical. We are businessmen. We have said it that we can't do it because I have not procured at that price. It depends upon the area. It depends upon the location. Throughout India, rate may not be the same. So it can't be, my lord. So we are disagreed. You could have, what at best you could have done, you could have deleted the items from me. But it's not the fact. You went on issuing indent and I went on giving because I understood that you accepted my disagreement. Please consider the above facts and positively do the needful. Malad, the resultant effective losses, my price of Malad, supply price of more than 70 lakhs, still they have blocked. And not only apart from that, Malad, I have a security deposit. It's a huge amount, bank guarantee, by a bank guarantee. That they have 2 crores, they have withheld because of this. We are not supplying right now. So our claim, my lord, limited to that extent. For the period we have supplied according to your indentment after my letter of disagreement, you have to give me that price and the, my lord, you release my security bank guarantee. This. Now your losses, kindly, my lord, page 70. My lord, clause. In case the price of a product is reduced for any supplier.
Page
70. That clause, your losses.
Oh, yes.
So that's the bone of contention. Everybody
yes,
nothing else.
Yes.
In case the price of a product is reduced for any supplier due to invocation of the price fall clause or any other reason, the same lower price shall also be applicable for the other suppliers who are having parallel RCs for that item. My contention is that in regard to the first part of this provision, that at best this can be applied in a situation where the other supplier having running contract for the same period. Clear to your losses? My running contract from entered into 30th March 2015 for 2 years. That means 29th March 2017. If they could have shown at best similar running contract having lesser price, then they could have, your losses, at best applied this provision. Otherwise, no. For a subsequent RC, somebody, my lord, entered into a different price clause, that cannot be applied to my running contract. Because Coal India Limited from time to time issuing contracts. Advertisement notices by the contracts. This is absolutely clear. This is for the subsequent periods. Singareni supplies. That somebody, Hyderabad company they, my lord, entered into a contract with a after 2 years or almost 2 years at a reduced rate. There might be thousands of reasons, your lordship. Production cost, material cost, carrying cost. How could I decide it, my lord, for the subsequent period? I cannot. I can presume, your lordship, what, when I'm entering into contract for 2 years, that this could be the price for the next. That I have to judge as a, my lord, supplier. That much capability I should have. And I did it. Therefore, my lord, my first contention, these clause cannot be applied or cannot be invoked by the ECL in case of me by giving reference to a running contract of another supplier for a subsequent period. Therefore, this is my first contention. Then, your lordship, even maybe the item may be the same. That's not the point. Second, your lordship, if any supplier does not accept the lower price, not admittedly I did not, CIL shall have the right to delete the item from the scope of RC of such item. They have not applied this provision. What they did, my lord, as I have placed at page 90, they went on issuing intent even after notice of disagreement, and then, your lordship, they accepted the supply. Then what would be the consequences? That's the point to be considered now. According to me, my lord, you have waived your first point, that the invocation clause, and you have accepted the terms. And procure. Then, your lordship, one thing, my lord, I must take your lordship to that. Just a minute. My lord, your lordship, there are two things to be taken note of. Page 86A. My lord, kindly see, this is extension of agreement. Because my agreement was going to lapse on 29th March 2017. This is a letter of 27th March. It is intended to extend the validity of the RC for a period of 1 month, provisionally, to maintain continuity of supplies of the exclusive of the accessories at the existing rates and terms and conditions. This is okay, man. Second terms, they might argue the final rates shall, however, be existing rates or the rates finalized against the tender number 14 this February 2017, whichever is lower. Then what they are trying to put upon me, it existing rate, or you have to accept the subsequent contract rate with whosoever maybe that have been entered into. Now take note of this date, 17. My claim relates to 2 periods. First, your losses, first notice, if your losses will have dated 30th November 2016. I have given reply on the very 19th December 2016. So, my lord, so far my ratio last 4 months period of contract, they have admittedly accepted my disagreement. There cannot be, because I given this letter on 9th December. You never replied to this. Okay, I'm deleting your item. Then, my lord, second part is, my lord, there are 2 parts. Second part, my lord, after 30th March 2017, you are extending RC for a month. Now, that is at what rate? So for the existing period, I am entitled to the rate which I agreed to. You cannot, because you have not applied the provisions. For the second part, your losses for the 1 month or so, Lord, according to me, I have not accepted this because of my earlier letter. Because I said I am not going to do that. Just for your benefit, you will execute the term, extend the term of the contract, and take me, force me to give it to for procurement for taking your production. That, my lord, one-sided thing you cannot do.
Okay.
Now, my lord, there are, my lord, replies and affidavit. If your losses kindly take up the affidavit in reply.
Yes.
My lord, my lord, page 11. Now, all are documented, my lord. All are documented. Kindly take note of this, my lord. This is 30th February 2017. After my disagreement, 19 December 2016. With reference to the CIL's RC supply of the above item, we have generated the following RE11s. Your losses for RE forms, date, such and such, your losses quantity that. The dispatch of the above explosives is yet to be made in spite of several follow-ups over phone to dispatch the above explosive immediately on receipt of this letter without any delay, so that it reaches the Assam-Bengal border within a week's time and intimate the van details well in advance to enable us to arrange necessary armed police escorts from border to Tikkok magazine. If you fail to dispatch the above explosive, our production will come to a standstill and will be left with no alternative than to procure the indented explosives from other sources at your risk and cost, and all action will be taken as per shall rest and times and conditions. Your poor delivery performance is noted for future dealings with you and will intimate it to our headquarters, Kolkata, for needful actions. This is Malad. Kindly have a look. That's they threaten me. Go on supplying like this. Then they issued the intent and then they accepted the supply. Therefore, your losses will find their ultimate order at page. What's the reason your losses? Very funny, Malad, according to me. Page 87. Their whole reasoning, your losses, last but one paragraph. However, page 87. This is to inform you that you have accepted the price fall clause. Since I have accepted the price fall clause, whatever they like, they can do. Without considering first the scope of the provision, secondly, whether they have acted in terms of the provision, that particular provision, even after letter of disagreement. Therefore, I am saying, this clause wrongly applied to me first, and the second year losses, after letter of disagreement, if they issue at the intent and go on supplying up to March, 29th March, they have to give me the price that they exist. I'll be relying upon one judgment of the Supreme Court on this. এই জাজমেন্টটাই তো ইয়ে কোথায় গেল প্যারাগ্রাফ কত ছিল 702 হ্যাঁ দেখি এটা কত এটা কত বার করে বইটা This is reported in AIR 2008 Supreme Court, page 357. I will be relying on paragraphs 19 onwards. 2008 Supreme Court 357. Ma'am, note meaning Bharat Petroleum Corporation Limited versus Great Eastern Shipping Company Limited. Copy আছে?
Yes.
Kindly come to paragraph 19 onwards. This is point of law decided by the Supreme. It is, as you also get paragraph, it is no doubt true that the general rule is that an offer is not accepted by mere silence on the part of the offeree. Yet, it does not mean that an acceptance always has to be given in so many words. Under certain circumstances, offeree's silence, coupled with his conduct, which takes the form of a positive act, may constitute an acceptance, an agreement sub silentio. Therefore, the terms of a contract between the parties can be proved not only by their words, but also by their conduct. Let's just settle, my lords. Now, kindly, your lordships, what was the fact? In our view, the principle of subsilence is clearly attracted in the present case. As noted above, after the extended period of charter party dated 6th May 1997 have come to an end on 31st August 1998, and the bids received pursuant to fresh invitation were pending finalization. While their letter dated 12th October 1998, the respondent had informed the appellant that they were agreeable to apply new rates for use of the vessels from 1st July 1998, provided all the 9 vessels are used. However, on 31st October 1998, the appellant faxed IOC message informing them of the extension of the existing coastal tanker fleet for the month of October 1998 at reduced rates, namely 80% of the charter party rates prevailing till 30th August 1998. On receipt of the said letter, the respondent, by letter dated 5th November 1998, protested against the revision of the rates. But this is vital. For the vessels not being considered under the new bid, and stated in unequivocal terms that it was not possible for them to accept the proposal of Oil Coordinate Committee communicated to them by letter dated 12th October 1998. Yet again, while responding to the appellant's fax dated 31st December 1998, whereby the respondent was required to sign a provisional charter party by 4th January 1999, while their letter dated 4th January 1999, the respondent pointed out to the appellant that usual practice is that pending finalization of the new charter, the existing terms and conditions of the charter party continue to apply, and therefore they were willing to sign the agreement as contemplated by the appellant based on the existing terms and conditions. It was suggested that an agreement may be signed between them for the period from 1st September 1998 until the matter was finally decided by the appellant under the tender on the existing terms and conditions, with the charter hire bearing provisionally paid on ad hoc basis at 90% of the rate which was prevailing under the existing charter party. As noted herein above, there was no response by the appellant to respondent's letter dated 4th January 1999, though it appears that by letter of even date, the appellant did suggest to the respondents that as a token of formal agreement, the said letter may be jointly signed by the charterers and the vessel owners. Admittedly, no such agreement was signed between the parties. Indubitably, there was no further exchange of correspondence between the parties during the year. Nevertheless, the appellant continued to use the vessel on hire with them under the time charter dated 6th May 1997. The conduct of the parties as evidence in the said correspondence, and in particular, appellant's silence on correspondence letter dated 5th November 1998 and 4th January 1999, coupled with the fact that they continued to use the vessel, manifestly goes to show that except for the charter rate, there was no other dispute between the parties. They accepted the stand of the respondents of silence and thus continued to bind themselves by other terms and conditions contained in the charter party dated 6th May 1997, which obviously included the arbitration clause. But that's another one. Therefore, your losses, all that I'm submitting for the 2 years running contract from November when they first gave the notice, and I gave the reply in the month of December. It ended on 30th, 29th March of the next year, 2017. I am entitled to the rate which was agreed, because I took an exception that I am not going to supply. But in spite of that, we should intend for that period and got supplied. So for the provisional part after March 27th, according to me, that clause will apply. They are just mere writing that the new tender clause for some other, that cannot take away my right to it. This is my suggestion.
Your Lordship, I'm being led by Pradeep Kumar Dotto, senior advocate. He's on legs, Your Lordship. However, I would like to indicate few points my learned friend has said, but Your Lordship will keep the matter after vacation when my learned senior.
No, why? After wasting so much time.
This week he is not available, Your Lordship.
Huh?
This week he is not available, Your Lordship.
Who is not available?
Pradeep Kumar Datta, senior.
I don't know.
Kindly keeps it up to the However,
Whether you will make submission here and now, or let the court allow the court to pass order.
Your Lordship will pass an order today, but we'll keep it after the vacation for him to make further.
No, pair is rejected. You submit.
Your Lordship comes to page 70. This is part of the running contract.
Yes.
This is part of the running contract dated 30th March 2015.
Yes.
My learned friend has placed this clause, price fall clause, which is the main point of dispute in this matter, Your Lordship. I will read the price fall clause. 7.2, Your Lordship. In case the price of a product is reduced for any supplier due to invocation of price fall clause or any other reason, the same lower price shall also be applicable for the other suppliers who are having parallel RCs for that item. If any supplier does not accept the lower price, CIL has a right to delete the item from the scope of RC of such firm and procure explosive accessories from other existing supplier reserve RC holders. So Your Lordship would mark this line, Your Lordship. In case the price of a product is reduced for any supplier, due to invocation of price fall clause or any other reason, the same lower price which has been given by the other supplier. The same
To whom?
Of a product is reduced for any supplier. So for in the present case, for example, it's between A and B. Then C has lowered. C is that any supplier. If C has lowered the price, then this price fall clause will be attracted. That is the whole point of this clause, and this has.
You are Coal India Limited.
Yes.
You are taking goods from certain supplier.
Yes.
Okay. Now, whether you can show that, look, that company is taking certain goods from certain circular, so they would be treated as a parallel circular.
Yes. Parallel supplier is based on the time period, Your Lordship. Reduced for
irrespective of the fact to whom they are supplying goods.
Yes, that is
where from it would be given.
This entire price fall clause. I'll read it again.
Singareni such and such company limited is not Coal India.
Maybe not.
Try to understand.
Yes, Your Lordship.
You are Coal India. You are taking goods from certain suppliers.
Yes.
All the suppliers who are supplied goods to you can be treated as a parallel RC holder.
No, Your Lordship.
But a certain company, he in Hyderabad is taking goods from certain supplier. Whether that supplier or a supplier of the Coal India can be stated to be parallel RC holder.
Depends on the time period, Your Lordship. If it's at the parallel time.
All India basis.
Yes, but that is the whole.
So that.
This I'll read it again, Your Lordship. In case the price of a product is reduced.
It is. What I understood, you just having parallel RC for you. That means.
Let me place this clause one more time, Your Lordship. The price of a product is reduced for any supplier due to invocation of price fall clause or any other reason. The same lower price shall be applicable for the other suppliers. So, any supplier and other suppliers. So these are happening simultaneously, not between A and B, but might be between C and D. Your Lordship would mark the words for any supplier and for the other suppliers who are having parallel RCs for that time. So C and D might be having another running contract having the same between the same time period. For example, if A and B is having the running contract from 2016 to 17 or 2016 to 18, C and D is also having a running contract between 2016 to 17, then this clause will be attracted. This is what is meant.
So the word according to any supplier will include all in India who are supplying LDO exclusive.
In the same field.
Irrespective of fact whether they are supplying to Coal India or supplying to any other company or not. Any supplier will include all, according to you. Okay.
Yes, according to me, but there's this catch during the same time period. That is what is meant by parallel RC holders, parallel running contract holders during the same time period. Now, this running contract is for from the period 30th March 2015, and it is for 2 years.
2 years.
So 16 and 17. So 30th March till 30th March 2017, this period is having this running contract is valid for this 2 years period. And your lordship would mark also, this is a running contract. They have accepted this price fall clause. They have not challenged the price fall clause. They have accepted. The price fall clause have already been accepted. They have supplied maybe on the basis of the fixed price, but they have accepted this clause. Thereafter, page 83, your lordship. Page 83, that is 30th November 2016. This is the show cause notice. That is the notice invoking the price fall clause.
Yes.
Yes, I'll read your lordship. It has come to our knowledge that Ideal Industrial Explosives.
Yes, I have read it.
Yes. And Regenesis have accepted firm orders.
Okay, so if your explanation is accepted,
yes,
that any supplier during that period supplying to anybody, irrespective whether Coal of India or any private company or not, during that period, whoever was supplying all across the country will be included as any supplier. Okay. Now you have second clause.
Yes.
That they disagreed.
I'll come to that, your lordship.
Okay.
If they have actually disagreed or not, I will come to that.
Okay.
So first, they have already accepted the price fall clause. They have entered into the contract knowing
Yes,
there's a
yes,
price
yes,
fall clause.
yes.
There was one in the notice inviting tender also. If your lordship would, I would indicate that also. It's there in the notice inviting tender. It's there in the running contract. Now comes this show cause notice. So it has come to our knowledge that Ideal Industrial Limited have accepted firm orders respectively from Singer and Collieries Company Limited for supply of LD explosives, cap sensitive and LD explosive non-cap sensitive to SCCL for a period. Now, your lordship would mark the period 2nd May 2016 to 1st May 2018. This will be considered as parallel RC holder. Your lordship would see the running contract is 2015 to 2017, 2 years. This is from the period of 2016 to 2018. So this will be considered as parallel RC contract. And in terms of that, at a prices lower than the prices at which they are supplying to CIL against CIL's RC with them, the comparison of prices are as under. So these are the comparison. We would like to inform you that as per the terms of 7.1 of CIL's RC dated 30th March 2015, price fall clause will be invoked against above mentioned 3 firms for the above items. We would like to inform you that you, being a parallel RC holder, having same prices for the above items, clause 7.2, which reads as under, is applicable in your case. It has been mentioned, elaborated, your lordship, why and how the petitioner is being attracted under this particular price fall clause 7.2. It's been particularly mentioned. I will read from the next para, your lordship. In case the price of a product is reduced for any supplier due to invocation of price fall clause or any other reason, the same lower price shall also be applicable for the other suppliers. So again, any and other, these 2 words, for the other suppliers who are having parallel RCs for that item. 3 words, any other and parallel. These 3 words are being interpreted here. If any supplier does not accept the lower price, CIL shall have the right to delete the item from the scope of RC, of such firm, and procure explosives accessories from other existing supplier reserve RC holder. Considering the above, you are requested to supply LD explosives and cap sensitive and LD explosive non-cap sensitive at SCCL's prices of 30,000 per metric ton and rupees 27,500 per metric ton from, your lordship would see the period, from 2nd May 2016 to 30th June 2016. So it's not because the running contract was from the period 2015. It's not that they have asked from the 2015. It has asked from 2016, from where the actual parallel RC holder have started. So the period is actually matching. They cannot deny that that we have asked for a different period. It's for 2016, during which the running contract is existing. It's existing from 2015 to 2017, and this is for the period of 2016. So any, other, and parallel, these three words is being satisfied here. Now, next page, your lordship, their reply to this show cause notice. Page 85. With reference to your above letter, we would like to bring to your kind notice that we are not supplying any explosives. So we are clarifying here. They are clarifying. They are not supplying any explosives to Singareni. And at the same time, we are not agreeing for the Singareni Collieries Company price for supply of explosives in future. We are going to supply the explosives as per Coal India Limited rate and not with the Messrs. Singareni Collieries Company Limited rate. This is for your kind information necessary action. So they might have interpreted in a different manner. They are explaining to the extent that they have not supplied. But the price fall clause is not limited to A and B. It depends on C and D also. So here they are clarifying that they have not supplied anything to Singareni, but they are not denying the price fall clause or saying that we don't come under the price fall clause. They are clarifying themselves that we have not supplied to Singareni. This is their reply. These three lines, they are not one saying that we are against the invocation of price fall clause. They are saying that we have not supplied Singareni. This is their reply, your lordship. It might be a misinterpretation. They're interpreting in a different manner, but this price fall clause can have an effect on A and B because of C and D, and they have to deny the invocation, and for that also there is a remedy available that their name will be deleted. So Coal India has given
name would not be deleted, item would be deleted.
Item would be deleted. So
if they does not agree, they do not agree to accept the price fall clause that other parallel RC holder has lowered down their price.
Yes.
So you have to supply at such rate. Then you have the liberty, you will get a right to remove that item from his RC,
Yes.
from his running contract.
Yes. And
you have not done it.
Yes.
Rather, you have stated that your such and such is extended from 1 year.
But the language is same in the running contract as well, your lordship. Page 70. If any supplier does not accept the low price, CIL shall have the right to delete the item from the scope of RC. So it's been mentioned in the RC also as well as the NIT. It's not the Coal India coming up with different languages and bringing different terms. This is as per the term given in the NIT as well as the term given in the RC. In the RC, it's clear. If any supplier does not accept the lower price, CIL shall have the right to delete the item from the scope of RC. So it's same thing is given in the show cause notice, that if you don't agree, then there is liberty, then the item will be deleted from the scope of RC.
Yes.
Yes.
You could have done it.
Yes, but
then dispute would have been otherwise.
Yes.
Dispute would have been regarding the payment till 1st May 2016 at the existing rate. Thereafter, 2nd May 2016 to 19/12/2016.
Yes.
Another rate from 20th to 12/2016, he would not supply it.
Yes.
But rather, you have extended.
Yes.
You have issued a letter. You supply the goods.
Yes, at the fixed rate. Yes, that I'm aware, your lordship.
This conduct.
The point that he has taken, your lordship, the silence, the point of silence. I can take the same point, your lordship. We have extended and we have stated that the final rates be, however, be existing rates or the rates finalized against the tender. In the extensions, page 86. These are the extensions, your lordship.
Yes, another thing. The extension is another thing. Same contract.
Yes, same contract. It's an extension. So I can also take the point that they are also being silent on this. The judgment that my learned friend has referred, I can refer that particular para and saying is silence, your lordship. They have also, after invocation of the price fall clause, they have also agreed to extend the contract, maybe at the fixed rate, but they have agreed to extend the contract. They are also agreeing to the extension, and they are also silent on the point. Either you delete my name, delete the item. They have also not taken that point. So they are also silent on that. We have issued these extensions, they have accepted it, and they have themselves saying that they have supplied it. So they are also accepting the terms of the contract, Your Lordship. So I am also
read this letter. Again, you read this letter. No, you proceed. No, you proceed. Yes, enter into the merit of the. You read this letter.
86.
Whether it is contradictory or what, how it would be construed or interpreted.
Yes. With reference to above, it is intended to extend the validity of the
So one is going on. One contract is going on. First, and a party to a contract is communicating to other parties saying that it is intended to extend the validity of the RC for a period of 1 month provisionally.
Yes.
Okay. To maintain continuity of supply exclusive accessories at the existing rate and terms and conditions. If nothing is written more, what will give more?
Yes.
Don't proceed. Yes. If nothing is written, then what meaning it will signify?
Can I, Your Lordship?
Huh?
Can I? May I?
Yes.
Yes. So firstly, I will harp on the word provisionally. So it's been extended provisionally. The next 3 to 4 words, to maintain continuity of supplies of explosive and accessories. So it's been extended provisionally, and it's also mentioned at the existing rates and terms and conditions. So right now, since there is no particular decision on the price fall clause, after invocation, they have sent a reply saying we are not coming under.
So whether the word provisionally will qualify in the existing rate, terms and condition or extension?
Extension and provisionally will go simultaneously.
The word provisionally, you are trying to trace on the word provisionally. Now, upon reading of these two sentences, whether the word provisionally will qualify the word extension or qualify the word existing rate, terms and conditions.
Extension at the existing rates. So all has to be taken together, Your Lordship. All the words are to be taken together.
Okay. So it was provisionally given. Although that party to the contract used the word existing, since by use of the word provisionally, that existing has not given finality.
Yes.
Rate was not given finality, according to you.
Yes, Your Lordship.
Yes. And in the next line, it was clarified. It would be your submission. The final rate, however, shall be existing rate or the rate.
Finalized. So rates finalized. Against the tender number, whichever is low.
It is a subsequent event.
Yes.
It is a subsequent event.
Yes. Next para, Your Lordship, you are requested to confirm your acceptance. So we are again requesting them that provisionally we have extended the time period for continuity of supplies. We have provisionally extended it, but you have to confirm, you have to give your acceptance. The third para. You are requested to confirm your acceptance of the same by return email. In case your acceptance or otherwise is not received by the scheduled date, it will be presumed that the proposal is not acceptable to you and action will be taken without any further reference to you.
Yes.
So we are including this line also.
So it is an offer.
No.
It is an offer.
No. No, Your
It is an offer of one party to a contract.
Price fall is already.
After expiry of the existing contract, it is an order. Yes. And in sense, unless there is express acceptance on your behalf, it would be presumed that proposal is not acceptable to you. And action will be taken accordingly. So it is an offer subject to its, whether it would be concluded contract or not, subject to the acceptance by other party.
Yes.
Yes. Then go on.
Your Lordship, can I?
Yes. Then from that point you have to accept.
No, but I will not make any length.
No. From that where court is now.
No,
You accept from that.
I will come to that place. but I have not heard before that where my learned junior had started. But this
One
point,
can allow to sing, but from that line where the other singer left.
no, this is not Antakshari. This is not Antakshari. That I will start from the last letter or last word.
Okay.
Every singer will, my lord, try to sing of his own. So let me sing of my own, my lord. Well, it's a very short point. I will not trouble your lordship. My learned junior has already placed the few documents to your lordship. Now, the moot point which is involved in this matter with regard to a policy decision of government of India. But the government wanted to have the supply of explosives cartridges.
Yes, court had learned this thing from submission made by the respective So according to it is a policy decision.
It's a policy decision, and why? Because the government is not put in a condition to pay a different price for the same item at the different level. That is the whole object of this position. And this price fall clause is that particular clause in order to get the parity between the rates of supply of these cartridges by all suppliers throughout the country. Now, my lordship will also make a note of that in India, the manufacturer of these cartridges, they have also got a limit. Every manufacturer of this explosive cannot manufacture more than a particular quota fixed by the government to him. Suppose if I am a manufacturer, I cannot manufacture of my own wish 1,000 tons and 2,000 tons. Whatever quota has been given to me, I have to manufacture only that, not beyond that. I may manufacture less than that, but at any cost, it is not more than that. That is the reason, so that one cannot use any monopolistic attitude, monopolistic stand insofar as the supply is concerned. These explosives are, my lord, used by colliery companies, by some chemical industries, and some other industries, my lord. So limited to that only. It cannot be used by anybody and everybody. It cannot be supplied to anybody and everybody according to the choice of the supplier or the purchaser. That is the whole logic. In view of that logic, the agreement which was entered into between the parties, that is on 30th March 2015 at page 67. Perhaps it was shown to your lordship. I will just take your lordship once to that document. My lord, kindly come to page 67.
Yes.
This is the subject, kindly sees the supply
of cartridge, explosive and accessories.
Accessories to all subsidiaries of CIL and NEC. So it is not confined to a particular subsidiary. Coal India is the head of the institution. Under Coal India, there are several subsidiaries throughout the country. So this is the tender is throughout the country. Supply is being made on the basis of this tender by the suppliers throughout the country. So therefore, it is all the subsidiaries. My lord, kindly appreciate the same item, which is the subject matter of the present writ petition, of which my learned friend is claiming a right. The same item is also being supplied to some other subsidiaries by some other suppliers. So therefore, whole object is to keep a parity, not only of the goods, but also
on the price. Now, my lord kindly sees the period of this contract was for initially 2 years. Lords will find from the duration of contract in the first page. My lord, kindly, page 70. It was shown to your lordship. I would just want to place once more.
Yes.
7.2, price fall clause 7.2. In case the price of a product is reduced by any supplier due to invocation of price fall clause or any other reason, the same lower price shall also be applicable for the other suppliers who are having the parallel RCs for that item. If any supplier does not accept the lower price, CIL shall have right to delete the item from the scope of RC of such form and procure explosive accessories from other existing supplier reserve RC holders. So this is the whole object of that parity. So, my lord, if I find the same item is being offered by another supplier at X amount of money, why shall I pay the Y amount of money to other supplier? That is the whole object. Now, my lord, kindly come to this contract was extended once up to April 2017 and thereafter it was extended up to lastly 30th June 17.
Extended up to
30th June 17.
Before that?
It is continuing.
Okay.
It is continuing. My lord, kindly note that this supplier is still a supplier. It is not that the relationship between me and the supplier has been terminated. They are still continuing supplying the same item of goods to us.
No.
I will do. No or yes will not do. The document will show itself. So, my lord, they in fact supplied the goods of the same nature even beyond this contractual period under a different contract. Under the same condition, had there been any grievance with regard to the grievance which has been ventilated in this writ petition, this supplier would not have been a supplier for the second time or third time for the same item and same nature. So therefore, kindly see the condition which was imposed that was accepted by them. My lord, kindly come to page 86.
Yes.
This is 27 March 2017. It should be 17, a typographical mistake.
Yes.
Extension of validity of the RC. Original is, my lord kindly sees, subject, extension of validity of the RC number so-and-so dated 30th March 2015, which was shown to your lordship at page 67. That is the original RC. That extension, with reference to the above, it is intended to extend the validity of the RC for a period of 1 month, provisionally to maintain continuity of supplies of explosives and accessories at the existing rates and terms and conditions. What are the terms and conditions? My lord, forget about all other terms, which is not subject matter of, yes. So only the price fall clause.
Price fall clause.
Price fall clause. Now that was accepted by email dated 27 March 2017. So therefore, the rate, well, first of all, my lord, kindly also make a note that a contract between this coal company and anybody, it is not just one fine morning, both parties sitting over across the table and signing the papers. Before actually signing the papers, there is a pre-contract agreement. All the suppliers come together because the tender terms and conditions are published much beforehand. Everybody reads the terms of the tender. Everybody go through that
and thereafter they are aware that what are the terms for which we are going to enter into a contract. Only after completion of that, only after a meeting with regard to that pre-contract agreement, then the final agreement takes place. So therefore, it cannot be said that coal company using its monopolistic attitude and dictating a term to accept by the contractee. So therefore, that was the first acceptance of the terms of the contract. Thereafter, the contract actually takes place in all black and white paper. And thereafter, it is further confirmed by them by an email dated 27 March 17. So therefore, there is no dispute with regard to the terms of the contract. There is no dispute with regard to the price fall clause is concerned. So if there is no dispute with regard to the price fall clause, so what wrong have I done? Because I have told them and I have shown them that look here, this is the rate is being quoted. This is the rate is being charged for the same item by another person. So you have to also accept to that. And that is my show cause notice. Now kindly come to my show cause notice. Page 83.
Yes.
It has come to our knowledge.
Yes, yes, yes.
Lordship has gone through. Now, what is the rate difference of rate? Kindly see, the
Thousand something.
syllable is also given.
1,000 and 1,000.
Whatever it is. So it is also shown there. Now, kindly see the reply. Kindly see the reply. 85. With reference to your above letter, we would like to bring to your kind notice that we are not supplying any explosive to Messrs. Singareni Colliery Company Limited, and that at the same time we are not agreeing for Singareni Colliery Limited price for supply of explosive in future. It is not the question that whether you are supplying to Singareni Collieries or not. It is Singareni Collieries is supplying at a reduced price.
Okay, you have got it.
So therefore, what is the reply? Reply is nothing. Reply is 2 lines reply, 2 points taken. One is we are not supplied to Singareni Collieries. My show cause notice has not said that you are supplying to Singareni Collieries. And second, that we are not supplying to Singareni Collieries and we are not the Singareni.
That express their disagreement to accept the lower price.
Even that has not been said in very many words. They have said, my lord, kindly appreciate this. I am specifically taking the point in my show cause notice that Singareni Collieries is supplying the same goods at a reduced price. So therefore, price fall clause becomes applicable. And you are also bound by that. To that, what is their reply? They do not say, no, 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 no. They say, we are not supplying to Singareni Collieries. Did I say that you are supplying to Singareni Collieries? We are not agreeing to for the Singareni Collieries company price for supply of explosives in future. Kindly read by the line, my lord. Kindly sees that the interpretation of this particular letter, what they wanted to mean. First of all, this speaks about the future, and second thing, we are not supplying to Singareni Collieries. I do not mean that. In view of this, my lord, now kindly come to a new tender 2017, 19, tender. To supply surface at 14, 17. But give me one minute.
Okay. You come to page 87.
Yes, 87.
1, 2, 3, 4 paragraph. How you interpreted their letter. Here you have stated. We have received your letter, your reply by such and such, informing that you are not supplying LD exclusive to SACL. At the same time, disagreed to supply at CCL at CCL price in future.
So what does it mean? I am not on the future aspect. This line which your lordship just looked at, what does it mean? That they speaks about the future contract. My lord, we are
They gave a letter on 4th April 2017 stating that we have not received any letter from you, that you have deleted.
Which page you are reading?
90, page 90. That you have deleted from the suppliers list for not agreeing the lower price of SCCL.
Odisha explosives letter. Odisha, that is writ petitioner's letter.
Writ petition, yes,
Yes.
page 90.
Now, before that, kindly come to
Page 90.
Before that, kindly come to 86 once. Last paragraph.
Yes.
You are requested to. I have told them that what offer we have got. You are requested to confirm your acceptance of the same by return email, positively by today. In case your acceptance or otherwise is not received by the scheduled date, it will be presumed that the proposal is not acceptable to you and action will be taken without any further reference to you. Well, let's stop here. But what we are ventilating today, although it is a writ court, the party, the writ petitioner, is trying to enforce his right under the contract. I am also defending my right under the contract.
Yes.
So neither of the parties would be
go beyond
the contract.
Yes, yes, yes.
So if that provision of the contract is static, there is no scope for having other interpretation of that contract, because the parties are ad idem with regard to that terms of the contract. And I have shown that how that terms is also applicable to them. He did not dispute to that. On the contrary, what he is saying, that I am not a supplier to Singlari Collieries. That does not make any difference. My lord, this is as simple as that. My lord, kindly look at in that way only. One line of English sentence here and there, my lord, will not change the whole scenario. Lordship is looking at the document only by virtue of a written contract. There is no scope for deviation of that contract. Now, what is the relief sought for here?
Now kindly see. They are asking for setting aside of the communication. That is the show cause. How the court can, my lord, set aside the show cause at this stage? Because the show cause has seen the finality. Show cause has been replied to. That means show cause has been accepted. I could understand one has come before the court at the stage of show cause, before taking any steps in terms of that show cause, that my lord, kindly look here, this is the show cause, this is the completely illegal show cause, kindly state. This is not that stage. The show cause reply, and it has seen the finality of the whole game. Now kindly see the prayer B. A writ in the nature of mandamus directing the respondent authorities, servant, etc., 2 to 4, to release the price of LD explosive and LD explosive as per running contract. Now kindly see, my lord, kindly go through the prayer P. It's a very important, my lord, kindly let us read by line.
Yes.
A writ in the nature of mandamus. Now they are asking for the mandamus. What for? Kindly see, the next 4 lines are important. To release the price of LD explosives and LD explosives, etc. So therefore, first mandamus seeking return of the price. What is the return of the price? The price at which they raised the bill and the price at which it was reduced to some other party. So difference of that, I have deleted that difference of that price. They are asking mandamus for return of that price. Now next line. As per running contract dated 30th March 2015. Now here is the point. As per contract. What contract says, I have already shown several times. How can they go out of that? How can they deviate from they themselves are admitting that contract. That contract itself is saying that there would be a price fall clause. So you are out. You do not have any cause of action. You do not have any right to ask the court for release of that difference of price as far as that cartridges are concerned. Because you were saying that as per the contract. Contract says it has to be reduced. Next, Shetshora Lordship kindly says, read in the provision, poverty, etc., etc. There is no other relief. I understand it was submitted about this bank guarantee. Where is the case made out of that? What is the prayer with regard to that? Many things and everything can be, my lord, said from the bar. But it is not to be granted by the court because it has to come within the 4 corners of the writ. So in my humble submission, my lord, this is not the case where the court should exercise its
power of
under the writ. I am on the writ. And this is my whole submission.
Yes. Anything in reply?
May I take your lordship's leave?
Yes.
My lord, I have not questioned any focus notice. Correct submissions. We have questioned your lordships the correctness and illegality of their final order dated 31st March 2017. This is not so-cause notice. Shall we look at this? This is not the so-cause notice I find. This is the final order that they will pay this rate. I will stand corrected if it is a so-cause notice. Final order. I objected to by a letter. That's my right. That's one issue. Second, my lord, this is in regard to prayer A. Prayer B, what I am praying for? Give me the release. There is no dispute in regard to the amount agreed upon. Give me that release amount. Whatever you have released. Balance you should give me. That's the prayer. Now the second I tell you, lordships, something said which is not in between the parties. I'm still supplying, I'm not still supplying. This is not a case either of the parties. But my instruction, I'm not supplying to them. Now, my lord, clause of the agreement is existing in the agreement itself. I'm not saying that this is not in existence in the agreement. I'm saying this is agreement. I'm taking the ground itself too. This is not applicable in my case, in the present case. And the second, even if it is applicable, I have disagreed with the rate. You have not said, you have not deleted those items. Rather, you issued intent for supplying. That shows you have accepted my disagreement. And therefore, you have to pay the rate. Now, why I'm saying, just your losses, I will not repeat that why I'm saying this is not applicable to my case. Kindly, my lord, page 70 to the clause itself. Now, I just, at the cost of repetition, in case the price of a product is reduced for any supplier due to invocation of the price fall clause or any other reason, the same lower price shall also be applicable for other suppliers who are having parallel RC for that item. Malad, I tell you, losses, price fall clause is there. When can it be applied? Malad, under the same contract, your loss is applicable to all subsidiaries. For the same period, if somebody quoted lower price, I quoted higher price. For one subsidiary, you accepted it my higher price. But subsequently for the same period, well, kindly remind the period from 15 to 2017, not from 16 to 18. Singareni 16 to 18. It's a different contract, not for parallel term, your losses. So you cannot apply the subsequent clause contract. You could have shown me that, look, under the same tender contract, I have given to X, who is giving lower price than you are giving to me. Therefore, price clause, I could have understood. What you are doing, you have accepted my contract in 2015, March, and you are showing Singareni 2016. Kindly have a look at page 83. Is it not parallel? Have a look at the very first paragraph.
Now, the word you reduce has been used.
Exactly. And how could it be, my lord?
It is not that if it is found that anyone has given offer of lower price, then your price will be reduced. It is not.
Not that.
If it is reduced means subsequent event.
Exactly. For
That
price
means-
fall clause or any other reason. Price, malad, any other reason, malad, this should be accepted.
Reduced due to price
clause.
invocation of price clause.
Therefore, this must
Or
be
any other reason.
Exactly. What they are saying, your losses, page 83. Kindly see the order dated to Ideal Explosive, 25th, 16, 2nd May 2016. All are 2nd May 2016. Has you got that? Page 83, very first paragraph. Have accepted the firm orders. It's a different orders under different contract. How could you apply to these? This is not because of price fall clause.
Okay.
So
But
I have
now you just give both of you give an intimation, this intimation only whether after issuance of this letter.
Which one?
Letter means
86A.
Okay. No, 30th November 2016. The whether petitioner supplied
Yes, they have. I have given you losses. 16-year losses. Kindly take up my.
Now, before issuance of letter of intent or letter of intent letter.
No, I tell you losses. Kindly look at page 90.
Page 90. Yes.
In third paragraph, second paragraph, third. In our letter, that is, we have clearly mentioned that we are not going to match Singareni company price. Then, after 19 December 2016, we have received valid RE11 intents
Okay.
11 indents we have received, we have
Okay, got it.
supplied. They have
Got it.
accepted it.
Your Lordship, this is their letter.
Maybe you have said it. Have you not denied in reply?
Even after the invocation, even after the issuance of the show cause notice, where we have stated that the price fall clause will be invoked, they have continued supplying. That
Okay.
they have continued.
Ashok.
Your Lordship, one more thing I want to state that
Conundrum, Ashok, a conundrum posited in this petition whether the price for clause
Sorry. And thereafter, Mr. Haldar intervened, and Mr. Haldar said that we shall file an affidavit of opposition. Affidavit of opposition has been
2
filed.
p.m. fixed matter.
2 p.m. fixed matter. Next matter. So, Shomeler, the issue was the issue was when the same set of certain employee have been given
A benefit.
absorption, whether you can discriminate to others, and it is their own decisions. Medical Corporation of India, that is their own decisions. They have given the other benefits. We have been deprived. This is the core issue, and we have been appointed as a contractual employee following the rules prescribed in the recruitment rules, and we have been serving the said post against the permanent vacant post from 2014. From 2014 till today.
To do it after vacation, it would be better.
I tell you, Lordship, this is
it's a matter of 2018.
That's why 2018. 2018.
আরে পয়সা আপনি ইয়েতে এফিডেভিট অপোজিশনটা নিয়ে নিন এই আপনি লিখুন তো the affidavit of opposition filed on behalf of the state is taken on record. Hardal Anet advocate appearing for the respective party is the matter for further consideration.
May I submit one thing subject to Lordship's kind considerations? A short point is involved, it is not recurrent. This side of the vacation, any day subject to. You will also considering the matter, you will also hard. My part I have concluded. I already take 5.
Regulation matter.
Yes, 5 and 7. No, it has been settled by the Supreme Court, our High Court, their own decisions. They have taken, not your Lordships will direct for regulations. They have taken their own decisions for regulation of the service for other sets of employees. Why should I be deprived? This is the issue. It will take only for my side 5 to 10 minutes to show your Lordship kept the matter because after hearing this side, your Lordship tomorrow, day after tomorrow, it is 2 p.m. matter is appearing, the next matter.
Actually, Mayor hearing court is to pass order. Only 3 days are left. You forget about the last day. Only to pass order, one judge will get 2 days. To pass order. Either I court, if in hearing matter, if open court dictation, the time will go. Court will not be able to hear.
No,
or I am to reserve the judgment.
Yes. Well, your Lordship
reserve the judgment. Either of
I take 5 to 10 minutes because I have concluded my submissions. If the Lordships kindly allow this indulgence, 2 p.m. it is appearing because due to this big matter.
Calculator থাকবে যায় যদি পারি. It will remain in the list tomorrow at 2 p.m. Yes.
I am mentioning item number 138, 39, 40. Same matter. One matter as in fact. But tomorrow, our batch matter is fixed at 2 p.m.
Okay, do it after vacation in that. Yes. Yes, এটা after vacation লিখি
My lord, so far item 137 is concerned, my lord.
Yes,
it will remain tomorrow at 2 p.m.
After vacation?
No, my lord, Mr. Mittal is appearing in this matter. Today he is not here. So, my lord, he is requesting if your lordship could accommodate tomorrow.
Hearing matter only 3 days, 4 days.
Mr. Mittal has concluded. Mr. Chakraborty is supposed to make submission for the state.
Okay, try your luck tomorrow. What can be done?
My lord, grateful.
He has also difficult, Mr. Mitro.
Oh, 137 also. Your matter?
138, 39, 40.
Yes, that matter is 138, 140. He is talking about item number 137.
Yes, 137 I'm talking.
137. Yes, come tomorrow. Let's see what can be done.
My lord, grateful. Grateful.
Item 20.
Who is the other side? 21. After vacation, you mentioned this matter. You give reminder that it would be fixed, don't worry. It has been upgraded matter. Okay, upgraded matter. Okay. Actually, if we can't take, it would appear under the same heading upgraded matter even after vacation.
That's my only prayer. It's a hearing matter. Affidavits are complete. Could it appear as a hearing matter?
So I am just making a not this week. That would be better for both of you. Not this week.
Same of
Huh?
139,
Huh?
138, 139.
Yes. Not this week would be justified of appropriate order. Yes. If not, whether 2 p.m. not this week, it will happen. Okay? Yes.